Good morning, everybody, and welcome. It's now just gone 10 o'clock, so I'd like to make a start, please. My name's Christopher Warren. I'm a reporter from the Scottish Government's Planning and Environmental Appeals Division, more commonly known as the DPEA. An application has been made under Section 36 of the Electricity Act 1989 for the construction and operation of the Scoop Hill Community Wind Farm, comprising of 60 wind turbines and other infrastructure on land approximately 5 kilometres southeast of Moffat in Dumfries and Galloway. I've been appointed by Scottish ministers to hold an inquiry and to prepare and submit a report to ministers on the proposal. Now, this will include my recommendation on whether or not consent should be granted. Now, the purpose of today's meeting is to discuss procedural arrangements for the inquiry, and that's been as set out in my agenda, which has been circulated. So I must stress now that there will be no discussion about the merits of the case today. Now, before I go any further, can I check everybody can hear me clearly? A thumbs up or down will probably suffice, given there are a lot of people on the call. In fact, I can't even see you all on the same screen at the same time, so you will have to bear with me this morning. That's great. I'm only seeing positive messages, so that's encouraging. There are some basic housekeeping points to mention, and these will be important given the number of people on the call today. So if you are taking part in the meeting, please keep your camera turned on if you have a camera. Please keep your microphone muted unless you're speaking, otherwise we'll get lots of echoes and it'll be very difficult to hear. Now, if you're simply observing, then please keep your cameras and microphones turned off. Now, if you have a question or you wish to speak at any point, please raise your virtual hand, which you can find on the top bar of the Teams application. Or failing that, you could use your actual hand. But again, please do bear with me because I might not see you given the number of people on the call. So if I'm completely missing you, please just turn your microphone and speak, and I shall come to you. Now, in terms of the time we should need to allow for this morning, I'm hopeful that we can complete business before lunch. That might be ambitious. If that turns out to be the case, we will take a break at a suitable point around between 12:30 and 1 p.m. We may take a short comfort break midway through proceedings as well. Now, as I mentioned, this meeting is being live streamed and the recording will be on the DPA webcast site should you wish to view it. So by participating today, you're consenting to being filmed and to the recording, storage and use of this material for webcasting, training and for the keeping of records that are accessible to the public. Now, I'll be making a note of our discussions this morning, which I'll circulate within 7 days. And this will set out all the procedural arrangements we discuss and hopefully finalise today. Now, I assume you've all had sight of the agenda, but if not, it would be worth you getting that in front of you. It's on the DPA website under the case reference, which is WIN-170-2008. So, without further ado, I'd like to now ask those of you who are actively participating in this meeting to introduce yourselves, please, together with any other key members of your team as applicable who are here on the call today. So can I start with the applicant, please?
Yes, good morning. So David Hardy, Hardy, duly qualified, but present purposes, I'm a partner in CMS. We are planning lawyers. And on the call from our side, we've also got Kirsty Kelshaw. She's down there as KK. She's legal counsel with the client community WIN-Power.
Thank you, Mr. Hardy. And for Dumfries and Galloway Council, please.
Good morning, sir. My name is Douglas Armstrong. I'm King's Counsel, the Scottish Bar, and I'm representing Dumfries and Galloway Council. And I'm here this morning with Leslie Montague from Harper MacLeod.
Thank you. Good morning. And for the Ministry of Defence, please.
Good morning, sir. My name is Ruth Crawford, King's Counsel. I'm instructed on behalf of Morton Fraser McRoberts, who represents the Ministry of Defence, and accompanying me in this call is Mr. Douglas Milne and Mr. Douglas Harvey.
Good morning, thank you. Was that Douglas Harvey?
Douglas Harvey, VEY.
Thank you. And for NATS safeguarding.
Good morning. My name is Sasha Rossi. I'm a control systems engineer representing NATS en route.
Thank you. Scottish Forestry.
Good morning. Andrew Kitching, Senior Operations Manager down in South Scotland Conservancy. I'm actually representing on behalf of Neil Murray, who's currently on leave, who is the conservator. So it'll be either one of us during the whole process.
Thank you. Patrick Juxter Community Council, please.
I'm Franca Bruno. I'm Vice Chair of Kirkpatrick Juxter Community Council.
Thank you. Good morning.
Good morning.
Moffat and District Community Council, please.
Good morning. I'm Liam O'Neill. I'm Chair of Moffat and District Community Council.
Thank you. North Milk Community Council, please. Anybody from North Milk? Ms. Wingfield, I can see you speaking, but I think you're muted. If you're on a computer screen, on the top bar, there is a little picture of a microphone. If you click on that, that'll be the solution. It's not working. I'll ask somebody if David, you're in the background. I don't know if anybody could from the office make contact separately with Ms. Wingfield to see if we could help her resolve that connectivity issue, and I'll come back to you. But I can see you're here, so that's good. So thank you. For Save Our Hills Moffat.
Clarence E. I'm Chair of Save Our Hills Moffat. I'm here with my colleague Harold Williams.
Thank you. And could I just ask now, who are there other individuals on the call which Save Our Hills Moffat represent this morning?
Harold Williams is here this morning.
Yes.
Also to represent Save Our Hills Moffat. He's our secretary.
In terms of the other individuals who are on the call, are you representing any of those as well as yourself and Ms. Williams who are on the call today? I can see Ms. Birchall's got her hand up.
Well, we're representing followers from the community. We're a small group which is supportive of renewable energies of all sorts. And our prime function with regard to the inquiry is to disseminate information that might not come their way through the normal channels from the developers.
Thank you. Ms. Birchall, I can't see you. Your video has gone off now. I saw you had your hand up a moment ago. If you would like to speak, you are very welcome to now. Otherwise, I shall move on.
No, thank you. Just to say that I consider Save Our Hills Moffat representing me. Yeah.
Okay, thank you. That's helpful. Okay, so I now have a list of individuals who I am expecting today. There may be others on the call as well, so I apologise in advance if this sounds like a morning register at primary school, but I'm going to work through in order so I don't miss anybody. So David Barron, do I have David Barron here, please? Currently. Sarah Birchall, we've just spoken, so good morning. No need to introduce yourself again. Paula Coupland.
Hi, yes, I'm here. Unfortunately, I haven't got video connectivity today.
No problem. So if you would like to speak at any point in this group, and you'll just need to just turn your microphone off and speak to me. Okay.
Thank you.
Thank you. Alan Hill.
Good morning, Mr. Warren. I was invited by the organisation just to observe, and so I'm looking forward to that. I'll probably leave your meeting somewhat earlier than lunch because I've got other things going on, but I'm sure I'll get an invite, I hope, to other further meetings that are going to take place virtually. Thank you.
We'll make sure you receive the note of the meeting. Yeah, that's absolutely fine. Thank you, Mr. Hill.
Take part. Thank you.
Lovely, thank you. Do I have Marin Jacobson? No. Terence Lee. I've had Mr. Lee, sorry, I apologise. We've already spoken. Ashley Lloyd.
Good morning to all. Ashley Lloyd. I'm based in Moffat. I'm sitting on one of the hills around Moffat at the moment, and I have a long-term interest in renewable energy. I've spoken at previous COPs, and I have a certain amount of technical expertise in the area of wind stealing, so I'd certainly like to bring to the meeting. Thank you.
Thank you, Mr. Lloyd. Mr. McClymont.
Good morning, Mr. Warren. My name is Alexander McLean, and I'm a messenger from God. Thank you very much.
Thank you. Eric MacDonald.
Good morning. I'm here, yes, but I'm also using the Murphy Farm Gmail thing rather than my personal thing, because there's two of us at the computer, Karen Megson and Eric MacDonald, and we are both community councillors for North Milk as well. So we're wearing a couple of hats.
Thank you, that's helpful. Neil McIntosh.
Good morning. I'm a member of the public. I hope to be able to make a representation about a community session at some point when that is relevant. Thank you very much.
Thank you. Karen Megson, I understand you're on the call with Eric MacDonald.
Yes, you sit behind me. Yes.
Lovely.
Oh, you.
Oliver Mundell.
You're on the call, member of the Scottish Parliament for Dumfriesshire.
Lovely, morning. James Patterson.
Good morning, I'm James Patterson. I'm a retired lighting engineer, and I'm the author of various external lighting master plans for dark sky places in the UK, of which Moffat is central to this study area.
Thank you. Elaine and Trevor Proctor. No. Okay. David Smith. Also, I saw David Smith on the call. In fact, yes, I can see you, Dave Smith.
Right, sorry, I've now got my mic on. It's Dave Smith. Forgive me. I'm a member of the public. I own the Bickley Arms Hotel, very involved in tourism and bringing tourists to and from Moffat.
Thank you. Good morning. And finally on my list, I have Faye Wingfield. Yes, good morning, Ms. Wingfield. I still can't hear you, I'm afraid. But I don't know if anybody's been able to make contact with you yet to assist. No. Okay, I shall send a quick message as we are speaking to see if I can get somebody to get in touch with you. Okay, so Is there anybody else on the call today who was expecting to speak or participate and whose name I haven't read out?
Good morning, Christopher. Sorry, I was moments late with a technical problem my end joining. I'm Mick Barker. I'm the Secretary of Moffat and District Community Council.
Good morning, thank you. Thanks for joining us. Is there anybody else? Mr. Lee, I can see your hand raised.
My colleague Carol Williams should be there. I haven't heard her introduced.
Did I miss you, Ms. Williams? I apologise.
No, that's okay. I'm Carol Williams. I'm Secretary of Safer Hills Moffat, and hope to be able to speak to you today about the possibility of a community hearing session.
Good morning, thank you. Yeah, sorry I missed you there. Okay. Ms. Wingfield, the office is trying to get in touch with you currently, so I've just had confirmation of that. So fingers crossed we can resolve that problem for you. Okay, so moving to item 3 on the agenda. This relates to the code of practice that the DPA has published. So unlike in mainstream planning cases, there are no prescribed rules for the conduct of inquiries held under Schedule 8 of the Electricity Act. So the DPA has published a code of practice for handling inquiries under the Act. Now, the code of practice in essence aims to ensure a fair, transparent and efficient process, and these broadly mirror current planning appeal regulations. Now, I included a hyperlink to the document in the agenda, so hopefully you all have at least a general understanding of what it outlines. But in short, it recommends flexibility in the choice of procedures. So rather than every topic or matter of dispute being subject to an inquiry session, matters may be dealt with through any combination of inquiry, hearings, further written submissions, or no further procedure where I have enough information to be able to guide ministers. With that in mind, does anyone have any concerns or objections to me following the code of practice in this case? It's usually fairly uncontroversial, as it's quite a proportionate approach. I can hear some speaking.
No objection from Alexander McLaren.
Lovely, thank you. Okay, so moving on to item 4, it would be helpful if you could have Annex A to hand for this item if you have it available. Annex A to the agenda, where I've set out my view on what might be the most appropriate procedures for each topic. Now, this is very much up for discussion, and as I've said, the Code of Practice gives flexibility on this. In any case, I should say at this stage that this should not be interpreted as a judgment on the relative importance of one topic over another, or the weight that may be given to them. It simply means that for some matters, I'm currently satisfied that I have enough information on that subject to be able to advise ministers. It's also common practice to have a session focused on conditions, and that doesn't mean I've reached a view on the merits of the case, because conditions have to be provided to ministers for in the event that they wish to grant consent, which may or may not be in line with my recommendation. Well, the Code of Practice explains what's involved in each type of procedure and the submissions which would be needed to be made by parties who are participating in advance. And I'll come back to deadlines for submissions later. But very briefly, in an inquiry session, each witness would expect to be cross-examined by those of an opposing view, and I may also have questions for the witness. It's not necessary to be represented, and individuals are welcome to give their own evidence and to question other witnesses. In a hearing session, there's no formal representation. So hearing sessions take the form of a structured discussion, which would be led by me. So they're more informal in nature, but are less well suited than an inquiry where there are complex technical issues in dispute. I recognise as well, and it's already been mentioned this morning, that there's appetite for a less formal community session of some form for individuals to speak about topics of concern. And there may very well be a place for this, but it's important also that we're mindful of the limitations of such informal sessions. So they tend to involve reading out statements which reflect what's already been said in representations, and these statements are made often without any questioning or challenge. Now, in a sense, that might sound attractive, but that won't necessarily further my understanding of any matters beyond what I've already read, as the issues raised can't be explored or tested. So there's a danger that a session of this type could ultimately be rather superficial. So any such session would need to be approached with caution to ensure the applicant isn't prejudiced by not being able to respond or make counter-arguments. Now, in contrast, inquiry and hearing sessions do allow matters to be fully explored, and my suggested inquiry and hearing topics, as well as matters where I'll be seeking further written submissions, are in part intended to explore the most widely held objections. I've covered a lot of ground there already, and we're kind of at the start, but just in general terms, are there any observations about what I've said so far? And I suppose in particular about what my kind of latter point around the community session and the limitations of that and the appetite for it. I'll have to go by raised hands, I think. So Mr. Lloyd, I think you were first, so I will come to you first.
Yeah, I would just say that having got to know many of the people in the community, I think the formal nature under which cross-examination is allowed might actually have a chilling effect on some people's willingness to participate and give honest testimony about how they feel about the place. So I think the community session is very important in terms of accessibility, because otherwise people view that as something they're going to feel very difficult to be participating in.
That's a valid point, and I share your concern about the nature of cross-examination in terms of public participation. In terms of what I said about hearing sessions, where that would be a discussion led by myself, do you have the same concerns over that process?
I don't have a concern about the range of processes that can be supported. All I'm saying is that I think at the stage, a group of people who are booking a community session, and thinking outside that, where there is a more formal tone to the proceeding, is going to be difficult for some and perhaps many to give what they will see as a personal testimony about how they feel about the place and how they enjoy it. Those are very personal statements rather than things that can be cross-examined, but do seem material to any decision taken about the proposed development. So that becomes the easiest way to make sure these people are engaged in the process and able to represent themselves. However much weight you give to that, because it may not change your understanding, but it does allow those people to feel heard.
Okay, thank you. Mr. Mundell, please.
I was just going to say, I've seen sort of community hearing sessions work really well, and I think where the reporters effectively chairing the meeting and passing questions backwards and forwards, I think that does work. And my suggestion would be, I think there's a session with an asterisk that's down for tourism, and I wondered whether that might be broadened out, to include community in its title, because I think one of the challenges people have with accessibility is this feeling that their comments or contributions have to fit neatly kind of into one of the kind of terms set out, and actually people have comments to make across all the topics you're covering, but maybe not kind of in the community sort of feeling is not in the depth where people would kind of identify as fitting into just one session. So I think that might be an opportunity to bring more voices into the process.
Thank you. Mr. Hardy.
Yes, I mean, good morning. Hear everything that's been said. Of course, full public participation is an essential part of the process, but it does have to be proportionate, and it does have to be fair. The concerns on our side would be that a community session effectively is a rerun of points that you already have. And the key thing here is that both you and ministers know what the community is saying. And if that's been put in writing, we're not sure of the utility of simply reading those out. The second thing is that been to lots of community sessions, it is difficult because the applicant is unable to really question. It can't do very much with the material that's provided. And I have left those sessions thinking, yes, the benefit is that the community have ventilated their concerns, but I'm not sure how far it's taken the process on. It may be that benefit is sufficient to say, well, look, that's in and of itself enough. But in terms of taking the process on and helping you decide the case, I've left those sessions not really feeling that it has. Third point is this: lots of people on the call. What would be helpful, I think, is to understand whether or not those individuals form part of another group or are members of another group, so particularly Save Our Hills, and if so, whether or not that umbrella organisation is able to better collect those and put things in writing or in another procedure, or genuinely whether or not we've got that list of 12, 15, whatever it is, individuals who are operating independently. So I think that's quite an important question. The appearance has been given of lots of people, but I wonder actually whether those are people who are all part of one or two groups.
Thank you, Mr. Hardy. And in terms of Mr. Mundell's suggestion around kind of broadening a potential hearing session, so there wouldn't be that, in terms of your concern around it being one way, and essentially the applicant not having the chance to respond and make counter arguments, would that address that part of your concern?
I'm not sure how helpful that is. If in fact you're just going to bring all of those repeats of submissions into the hearing session, because you've got my basic point is you've got the material anyway. If it was felt that they had to be given orally, then yes, with the ability to respond would be better than having just a kind of one-way evening session, as has been suggested. But the bigger point is we think you have got the information.
Thank you, Mr. Hardy. Mr. McIntosh, please.
Thank you. By way of background, I was Chief Executive of Dumfries and Galloway Council in the years 1985 to 1992. And my experience throughout that period as a Chief Executive of a large body was that in an area which is widespread, rural, small communities, individuals with a keen interest in their area and its environment, that personal contact was absolutely vital. And that meetings with the community were vital. In giving that opportunity, I stress I'm a member of no body associated with this. My concern is that in an area like this, small population, large area, the environment critically important, the economy important, all of those issues, people should have the opportunity to make their individual contribution if that opportunity is there. And it's vital that they feel that you are not just simply receiving refined quantity of professional contributions, but also the feelings of people within their own community. Thank you.
Thank you, Mr. McIntosh. Ms. Williams, please.
Thank you, Mr. Warren. I think a community session, and not necessarily an evening session, it could be a daytime, is really vital in this particular application. This is a huge development. The application has already run over some 3.5 to 4 years. Many of us here and many others have submitted written representation, but we then get very little feedback on that. And certainly for my part and on behalf of Save Our Hills Moffat and anyone that has communicated with us recently, we are more than prepared to submit any precognition documents that are required. I can assure Mr. Hardy that we intend to be well prepared, coordinated, and what we would like is simply the opportunity for our community to at least witness the community session and see the people who have been working so hard on their behalf to get us to the public inquiry stage. I think there would be a lot of very bemused and disappointed people if a community hearing session did not take place.
Thank you for that. That's all. That's noted. In terms of Mr. Hardy's point around, does Save Our Hills, Moffat, and potentially other groups represent the majority potentially on the call, and whether that could bring people together for a session? Is that a reasonable expectation at this stage, or is it too early to kind of say that?
On the part of Save Our Hills Moffat, we've already offered to bring interested parties together, and we have succeeded in coordinating to some degree a few of the people who want to speak. However, there are people on the call today whose it will come up in your agenda who prefer to represent their own interests. For example, Moffat Community Council, the three community councils are represented here, and I understand that Ashley Lloyd and Paula Copeland will come to you later in the agenda with requests for speaking time. Whether or not that's part of the community session is of course down to you.
Thank you. So I'll come to individuals with their hands up in the order that they're numbered. So it's Mr. McIntosh, please. Is your hand? You're muted, Mr. McIntosh. So
You're taking it down. Thanks.
No problem. It's fine. Apologies, I can't recall your name given the numbers of people on the call, but you're down as Alison, gentleman. You're muted currently.
There we go. It's Alan.
Alan.
There's no gender issues here. It's definitely Alan. I'm listening in, and it's all been done before. I don't know why you have to go over another process in regards to meetings or hearings in public halls or public spaces, whatever, for a whole day meeting. It's all been done. You have those representations, if not in front of you, within your grasp. So I'm in agreement with Mr. Hardy. I'm just a member of the public, and I've put my representations to you. And here I am sitting, listening to the timelines and process. Well, what I thought was going to be the timelines and process of Scoop Hill development, which is turning into something else. I think you've already got the information. You've had representations from Watt the farmer and Mr. Hill, the member of the public, the community councils, Save Our Hills. You've had all these representations. So why you have to go over that ground again is beyond me.
Thank you, Mr. Hill. I mean, I certainly won't be letting today turn into something else. It will be very much me considering and listening to views on what process should be followed. So this is an important part of that consideration. I don't want to, I'm certainly not making light of the views that are being expressed here, and I'm keen to ensure that people have proportionate opportunity to be part of this process. What that looks like is kind of that'll be a outcome of today, having listened to the different views. But it's helpful to hear your perspective on that. Ms. Williams, I think you've still got your hand raised. I think that's just left up, but if it's not, leave it up. Thank you. Mr. Barker, please.
I would just like to say that on behalf of the Community Council, I anticipate we will have further contributions to make from the community. And I would like to think that the community's voice does get the chance to be aired, as opposed to being merely seen as a series of words on a piece of paper.
Thank you. Ms. Bruno, please.
Thank you. I agree with Mr. McIntosh and Mr. Barker. I think it's very important that we do have a community session. One of the things that came out for me on this, and this is the first time I've taken part in this process, so it really is quite unnerving, as Ashley Lloyd was saying. But one of the things that's come out of this for me is how little the community or the opinions of the community are actually taken into account. Actual human beings. It's all about landscape and visual effects is very important, as is nighttime effects and so on. But it's the people at the end of the day that matter. It's the people that are important. And I was actually surprised at how little the people are taken into account when a decision was being made, certainly at local authority level. That's what came out of it for me as part of this process. So I really do feel quite strongly that a community session is held. We have put forward our views as Kirkpatrick Juxta. We did our survey, as what we should have done, and the community came out well against the wind farm. So I was actually quite surprised, as I say, at how little regard that was given at when the decision was taken at local authority level. So I do think, again, a community session is important. Thank you.
Thank you. Mr. Smith, please.
Yeah, I agree with the last couple of speakers. When we talk about proportional understandings and commitments, the proportion of the passions of the people that are living in that community are absolute, and it's very hard to compare to an office up in Edinburgh or anywhere else. But I do understand that the fact that representations have been made. What I can say without a shadow of a doubt is that the fact that we're getting this opportunity to have a second bite at the cherry and look at this thing is paramount importance. And I think that will see the real people coming out in our community. And the reason I say that is that I think we're all in a position where we've seen over the years some new ideas coming from council or government, whatever, and we all feel cowed down to accepting that that's what's going to happen. It'll be a fait accompli. I've actually heard personally well over 50 people in the community saying, yeah, but what can we do about it? They're going to do it anyway. It's forestry land, it's government, they want it. And in actual fact, they feel as though the case is lost before we even start. I think the fact that we're having a hearing with a genuine understanding and perhaps with some sincerity, the various bodies, individuals can put it to the community. And I suspect very strongly that you will actually see just how deep the feelings are in Moffat if they feel they've got a chance of overcoming this decision.
Thank you, Mr. Smith. Mr. Mundell, please.
Yeah, I was just going to say, Mr. Hardy, sort of in his pushback, had suggested, that you've got all the information you need. And I would just kind of re-emphasise the point, when you look at a lot of the individual and community submissions, they are talking on the topics that you propose to inquire further on through this process. And I think it's about whether it's the right thing to ask individuals to come and make, for example, submissions on the landscape and visual aspects, in the formal sort of inquiry session, or whether there would be a chance for them to contribute their views in a hearing session. Again, I look at energy policy, for example. There are some individuals in the course of their representations who've made comments on those. Again, whether they would feel they have the expertise, to speak in the in that specific session, or whether that's just part of what they want to say. And I think there will be questions that arise out of that for both the applicant, and for yourself. And I don't see what the downside, to exploring some of those themes in more detail would be.
Thank you. I'll come to Ms. Wingfield, then Ms. Birchall, and then I will and Ms. Cooper, you've got your hand in just in time. I'll come to you as well, and then I am going to move on. I'll reflect on this as we progress. I hear the message loud and clear. Ms. Wingfield.
Hello.
I can hear you. That's good.
Yes.
Good morning.
Things are finally working. Thanks very much for your patience.
No problem. No.
I am wearing sort of two hats at this juncture today, but as I speak now, I'm actually speaking as the voice, the chair of North Milk Community Council. I do taking on board what Mr. Hardy said about whatever the community wants to say has already been said in written submissions. Effectively, that could be said for the applicant's point of view. So, why we're having an inquiry. But setting that aside, certainly for us as a community council, given that we are a statutory consultee, I certainly would welcome the opportunity as a representative of the community council to be able to put forward vocally the point of view of the community again. Thanks.
Thank you. Ms. Birchall.
Thank you. I would like to just briefly say I support the idea of a community session, largely because the community can bring local knowledge to the inquiry, which the developer doesn't have. They're dealing from a distance. They're dealing with policy and planning law, whereas the community can bring new information to you about the locality and the environment. And I think that's really important, as well as the technical expertise that some of the people who want to speak have. Thank you.
Thank you. And Ms. Cooper, please.
Yes, the applicant has submitted a detailed EIA, and for those responding, consultation responses can often be very limiting. And there are independent experts resident in the area who would very much welcome the opportunity to elaborate on our responses. And in that regard, I don't think Mr. Hardy really has all the information that he thinks he has. Thank you.
Thank you. Okay, that's it's really helpful to hear the different views on this matter. Before I move on, can I just pause and just ask, does Mr. Armstrong and for the council, do you have anything you would like to add on this particular point? I appreciate it's not your main kind of business here today.
The council are happy to leave it up to you in relation to this matter. Obviously, you've heard a number of responses from members of the community stressing the importance of a community session. Certainly, in my experience, these sessions, when controlled, work very effectively in allowing parties to come forward and make important points. But the council is obviously content you're taking the decision on this matter, and we've got nothing further to add on that.
Okay, that's helpful. Thank you. I shall reflect on this as we progress through this morning. I think there is scope to accommodate this, and I'm keen to not just kind of progress, paying no attention to what's been said quite strongly this morning. I'm attracted to the idea potentially of thinking about how the tourism session that I've indicated is required could be expanded, as Mr. Mundell suggested. I think that is a potential means by which we could broaden out the opportunity to have some focused involvement. But I will give some careful thought to this. I can see a couple of hands have gone up. Is it a pressing point now, or is it something we could return to? Sorry, is it Mr. Barker?
I also happen to be the chair of Visit Moffat, and it's a recently reformed organisation after a series of retirements. We have not had the opportunity as Visit Moffat to make a presentation, and therefore, should the issue of tourism be opened up for a community session, I'm sure we would be able to provide and would wish to provide a perspective on the situation. So I'm supportive of where you have just raised your last comments. Thank you.
That's helpful, thank you. Okay, I'm going to move us on. I'm conscious there's a lot of business to cover today, so I don't want to focus on just one point. And okay, so with all that in mind, I'd actually like to touch upon a matter which is not identified for a dedicated inquiry or hearing session currently, and I think we're going to need some discussion about that this morning, and that's the effect of the development on the Eskdale-Muir seismological recording station. Now, I've indicated in the agenda that my current view is that a conditions hearing is likely to be the most appropriate place to discuss the matter of the Ministry of Defence objection to the potential impact of the development on the Eskdale-Muir facility. Now, given the work on establishing whether the applicant's proposed mitigation scheme would be effective is ongoing, and given the request from the Scottish Government's Energy Consents Unit to progress with the inquiry without delay and based on available evidence now, it seems to me that if that's how we do progress, that's the only means by which I can meaningfully consider the issue is through whether or not a suspensive condition could be used, and if so, what that would look like. Similarly, this might be the extent of any necessary discussion over the NATS safeguarding objection and aviation radar mitigation, but they're two separate points, which I'm very conscious of. So I'd like to focus on the Eskdale-Muir matter first. I'll come to the applicant, followed by MOD, please. So, Mr. Hardy.
Yes, sir. Obviously, this is a matter of central importance, and I've got quite a lot to say on this. So, just by way of background, and also just before I start, I can say I think that there is an agreed position. Ms. Roberts on the call. There is an agreed position with the MOD, but I'll come full circle. So the applicant has commissioned a technical mitigation proposal and submitted that to the MOD for review. As you know, that was sent to the ECU in March 2024. Preliminary assessment has been carried out. There has also been a meeting, an early meeting of experts, which took place on the 5th of September. Without getting into the technical detail, I'm sure you know this, but it is a borehole seismometer that we're talking about. There is a test which is going on. There is a need for the data. Obviously, the EC knew about that. We were, when we saw the note, we thought we weren't quite sure how that was going to work with respect, because if it was just going to be a condition session, I think the MOD's position would be, well, look, that's got to be on the basis of the current science, and if, as we would challenge that, and we would put in what we thought was the direction of travel, a hearing session on conditions just wouldn't be fair, proportionate, or indeed appropriate to deal with that. There would have to be, in our submission, evidence from both sides, from the applicant and the MOD. Now, in terms of process, I don't know whether you have seen the correspondence which came in yesterday.
Yes,
I believe it was from Nick Jansen, basically saying, look, timescale is a matter for you. So he's just reading out that last paragraph for the benefit of everyone else on the call. ECU acknowledges future position of the MOD may change in respect to wind farm development, procedures and timings within option one are a matter for the reporters, not for ECU, and confirm that neither ECU officials nor the Scottish ministers have any lockers to instruct or determine procedures at inquiry. So in short, as you know, it is a matter for you. So there is a need for proper a proper look at this, and that is data collection. We need to make sure that the MOD has time to process all of that properly. We've been in contact with them, and we are aware of a couple of constraints. Mr. Dr. Bowers, I think, is attending an international conference in the early part of 2025. So where we get to is this. We think this is a matter on which substantive evidence needs to be heard from both sides. The MOD agree with that on the basis that we wouldn't just agree the position in a condition session. That can't be done on any sensible basis for December. And what we are proposing, therefore, is a split, and to have the sessions that everybody else on this call, I suspect, is interested in, L&V and other things in December, but then to have a second week in the middle part of 2025. And the MOD suggested June, and we said, yes, that's fine. Without being prescriptive and setting a date now, what I wondered whether a pragmatic suggestion, and one that I discussed on a pre-call this morning with Ms. Crawford, was to have a second PEM, so just dedicated to Eskdale-Muir, potentially in, say, March, for a progress update to tell you this is the data that's being collected, this is where the MOD has got to with its analysis, and then to set out the procedure just in relation to the technical side of Eskdale-Muir. So lots of work going on in the background, hugely important, can't be dealt with sensibly, we would say, in within a condition session if there's going to be any type of evidence, and we really think that you do need to hear the evidence on that. And ultimately, I'm hoping that there is an agreed position which Ms. Crawford can confirm with the MOD about how to sensibly take it forward.
The challenge back, I suppose, Mr. Hardy, is the evidence isn't actually available yet, and that's the elephant in the room here. In that I've been instructed to carry out an inquiry now, and the timescales are. I'm not obliged to follow ECU's request to progress to the timescale that I previously indicated, but equally there's an expectation from ECU and from ministers and also from the courts to progress inquiries efficiently and promptly. And I do have a concern about what you've outlined there. I think it's in terms of they're the timescales that have been previously indicated. Before I come back to you, Mr. Hardy, I'm going to ask Mr. Munday. I can see your hand up. I would like to bring in Ms. Crawford first for Ministry of Defence, if that's okay. Ms. Crawford, are you?
Yes.
Can have your views, please? Thank you.
Yes, thank you. I wonder if I might just briefly deal with an easier matter. And I should have indicated, although I'm here principally to represent the Defence Infrastructure Organisation's interest in the array. Sir, you may have noted there's also an objection to, as regards lighting, should consent be granted. That item regarding lighting of the turbines could, of course, be sensibly addressed at a conditions hearing session. So just to flag that up, lest sight, no pun intended, is lost of that matter. More substantively, if the existing science which underpins the safeguarding model for the array is to be challenged by the applicant, the MOD's position is that it would be wholly inappropriate to address that at a hearing session on conditions. Not only would it be inappropriate, I also would suggest it would be less than informative for you, sir, in making recommendations. The MOD's position, for the avoidance of doubt, is that the science is what it is at present. The applicant is proposing something which is innovative and has never been suggested before by other developers. Other types of mitigation have been proposed, but this is an entirely different approach which is being suggested. It is still, it would appear, very early days. I think the tests are being carried out more or less as we speak. There will be preliminary results forthcoming. The MOD, of course, has no idea what those results may say. They have no idea when they might be provided with those results, and thereafter they will require time to analyse those results and see whether or not the mitigation which is proposed, sometimes described as augmentation of the array, whether that would properly ensure that the ability to detect seismological events, in particular nuclear explosions across the world, would be prejudiced. And I'm sorry for the hyperbole there, sir, but it's just to underline the importance of this array, not just nationally, but internationally. And I need hardly remind anybody in this room of the troubled times we live in. So the MOD is crucially concerned that there is nothing done should there be any consent of this development. Nothing is done by that consent which would undermine the ability of the MOD to safeguard the detection capabilities of the array. And I should also say, in fairness, and of course the developer is well aware of this, as is Mr. Hardy, that the MOD has doubts based on the advice of its subject matter expert, Dr. Bowers, that what is proposed would safeguard the array. But nonetheless, of course, as a responsible public authority, the MOD always has an open mind to these things. But its open mind does require careful thought and careful consideration. So it seems to me, with respect, and again, on the pre-meeting call, I raised this with Mr. Hardy, that if the inquiry is minded to address the safeguarding of the array in a condition session, perhaps in December this year, as indicated in the draft timeline, that could only proceed on the basis of the current methodology based on an algorithmic tool calculating the seismic ground vibration, which is predicted to be emitted by this proposed development. It would be wholly uninformative, unfair to national and international interests, and inappropriate to have a hearing session on conditions to address matters which may yet be disputed, will certainly involve complex technical evidence, and to ensure that the report you, sir, have a proper understanding. It seems, with respect, that should be addressed at a hearing session if the science is to be disputed, which it would appear it is. That being said, the MOD will, of course, cooperate and liaise with the developer and its experts. It's been indicated correctly that there has been a meeting. It would be helpful, depending what timescales we may be working to, and I've already indicated as much to Mr. Hardy. It may well be useful for the MOD to be provided real-time data rather than being provided with data once, as and when all the experiments have been carried out, and then having to react to that. Maybe a more proactive, collaborative approach might be envisaged, but these are matters, depending on your decision, these are matters which can be dealt with in discussion with Mr. Hardy and those who instruct him. So far as the suggestion is concerned, if we're not to have a hearing session on conditions relative to the array, and I can understand why the developer would not wish that, the pragmatic suggestion is not something which the MOD would resist. The timing of when there might be an inquiry session into the array, of course, cannot be set out with any degree of certainty at this stage. Clearly, the applicant still has a lot of work to do, and clearly the MOD, being a responsible public authority, will require time to address that, noting, of course, that Dr. Bowers has other commitments relative to the nuclear test ban treaty, and as an expert in relation to that and inputs at international conferences on that. That being so, the pragmatic suggestion of having a second pre-inquiry meeting, perhaps in March, perhaps in April, to see where we are, may well have merit, and then a view could be taken as to when, if you, sir, thought it appropriate, an inquiry session could be convened. Of course, just scoping forward, if there were to be a pre-inquiry meeting in March or April, and a timetable set out at that time for exchange of statements, reports, core documents, and the like, it may be that a June inquiry session might be somewhat ambitious. and might be going, hackneyed phrase, too far, too fast. But the MOD is content to adopt a pragmatic approach, but has its doubts whether adopting such an approach, parties would be in a proper informed position to proceed to an inquiry session as early as June. But it may be that that is the case if parties can work together, as I say, in this collaborative and cooperative approach.
Thank you. It might be too difficult or impossible a question to answer, but what would be your best guess in terms of what may be a more realistic timescale?
I suspect it is impossible to guess. It would also depend on the availability of of Dr. Bowers as well, who is a busy man, and this isn't just within his remit. He has other things to do. I would have safety. I thought we'd have at least a further month into the July period would probably be more doable, but it is impossible. It's, might as well stick my finger in the air because the MOD does not know what material is going to be presented to it.
Yeah, and then we're running into the issue of school holidays and people's availability for that reason as well. In terms of if I was to decide to progress based on the evidence that's available to me, what's your view, Ms. Crawford, in terms of whether there would be value in an inquiry session to test the existing evidence?
Well, I don't know the extent to which I don't think the existing evidence is challenged as such, but Mr. Hardy will no doubt say if I'm wrong on that. Where there would be a dispute as to whether or not it is possible to mitigate the impacts. I don't understand, although it would be useful to know, I don't understand that the existing threshold as it's described of 0.336 nanometers is in dispute. I don't understand it to be disputed that that threshold would be exceeded were this development to be consented, having regard to the existing algorithmic tool used to predict seismic ground vibration from turbines. What I do understand to be in dispute is whether it's possible to mitigate the effects of the otherwise predicted seismic ground vibration, which would be emitted from the turbines. But I may be wrong in that. And if I am wrong in that, then, and I'm not sure what evidence Mr. Hardy would be proposing to lead in relation to that, the question of the threshold and the predicted SGV from Scoop Hill. But if that were to be challenged, and there's no suggestion thus far that it is to be challenged, if that were to be challenged again, it seems to me with respect that it would be inappropriate to deal with that in a hearing session.
It might be helpful if I clarify in terms of my thinking around the why I suggested a hearing session might be the right place for this, and it was my understanding that essentially there is an accepted position between the applicant and MOD that that the situation would need to be mitigated. A mitigation solution is required, and there is a unresolved matter as to whether or not that proposed technical mitigation would successfully mitigate the impact of the development. In the absence of that mitigation being confirmed as being effective or being disputed as being effective, then whether or not a suspensive condition could work to be able to say the development, this is obviously on the assumption that development was being consented, then would the development would not be able to take place unless and until that mitigation had been established and agreed. I appreciate there's lots of, I don't want to get into the merits of whether or not, but I just want to clarify my thinking around where a conditions hearing would fit into this, rather than this being something where the evidence would be tested more thoroughly, I suppose.
Well, Mr. Hardy and I have been here before with another development, Fosside, where we did have an inquiry session into proposed mitigation, and thereafter the applicant proposed a suspensive condition. To put matters short, my submission on that, which I think was accepted by the ministers, was that a suspensive condition with all those ifs, buts, maybes and hypotheticals simply would not meet the questions of validity of a planning condition, suspensive or otherwise. And Fosside was in the context of the reporter having been informed on at least some of the science, and indeed to an extent informed in relation to a number of doubts and uncertainties rather than the certainties. that a suspensive condition in those circumstances wouldn't be appropriate. Now, obviously, this is a different development and it's a wholly different scheme which is being proposed. I accept that. But I also would venture to suggest that we might be in similar territory come December, because we'll still be in the realms of ifs, buts, uncertainties, and various hypotheses still to be tested. As I say, the MOD doesn't have a view on the merits of the development or anything of that nature, but it can understand that the developer would probably wish to come to you, sir, with a more definitive proposal, so that at least some of the uncertainties could be aired and decided, and the level of uncertainty, the level of risk could properly be assessed.
Thank you. I will come back to you, Mr. Hardy. Obviously, I'm conscious there are a few people wanting to speak, so I'd like to come to those people first. Mr. Mundell, please.
Yeah, I was going to say, I mean, I don't feel that this is in any way, what's being proposed is in any way proportionate, because the applicant has been working on this project for a number of years. And I think if any other party was coming here today and inviting you to go down a speculative route, looking at the future direction of travel, on any number of other issues, then you wouldn't be, I don't believe, receptive to that. And I would have thought, if this is a known issue, it's not something that's just popped up yesterday. This site's interaction with the seismic array has been known since the applicant chose it. So I think if they're not ready, to bring forward best evidence, I'd have a question of why they'd, progress with the application. At this stage, I think it's not fair on the community to talk about, a significant delay to the process. And secondly, in relation to the conversation that's ongoing, I know that Ruth Crawford's representing the MOD, but I think the level of seriousness which is attached to this issue would attach political interest as well. And I think that those processes also add an uncertainty around the timescale, and it would clearly be up to UK government ministers as well, I think, to reconsider it, given that what's been proposed is novel and very different to what's been proposed in the past. And I'm sure they want to hear the expert evidence on that. So I just don't think the timescale of this is at all clear. And for any other matter, you would look at the situation as it is now, not try to imagine what it could be in the future.
Thank you. Mr. Lloyd, please.
Yes, I'd like to endorse, I think Ms. Crawford had to say. There are a couple of things I'd like to pick up on. One is, I think the lighting is not just a matter for a conditions session, because of course it applies to, and has impacts on much wider sets of issues that might be obviously dealt with in a community section. So I think that is something that can't just be constrained to a conditions section. But I would like to pick up on the point that the sensitivity of the instrument at Estilmuir has been degraded over the last 30 years of installations of wind farms in the area. That's not a matter of dispute, but what is important to recognise here, that should the mitigation actually provide the benefits that Mr. Hardy suggests it will, that is not necessarily a reason for promoting the construction of Scoop Hill, for the following very important reason. For 30 years of turbines in the area that are already impinging on the Estilmuir array,
sorry, Mr. Lloyd,
being upgraded.
Sorry to interrupt you. We're straying into kind of territory of kind of merits of the case and the arguments there. So what I really want to focus on is what's the appropriate kind of process for considering the matter, rather than us actually considering the matter now. I hope that makes sense.
Okay. Well, there are wider impacts of this decision that bear on technicalities, but also on the impact of that on actually the environmental footprint of the whole of the area. So I think that session should be more open and not just between the two parties discussing it at the present.
On the point of aviation lighting, you'll see I've suggested a hearing session on nighttime effects. We'll come on to that, so I don't want to discuss that now and muddy the waters, but just to make a note of that now. It's Mr. Armstrong next, please. Thank you.
So just in relation to this discussion and the timescales, I do have a concern in relation to leading evidence on landscape and policy matters in December, and then perhaps not having a second session until sometime in the summer, and ultimately a decision, your report being produced later in the year, and a decision from the Scottish ministers perhaps coming out at the end of 25, 20, or the beginning of 2026. Obviously, when you write your report, will have to consider what the policy position and indeed what the cumulative position is at the time you write your report. And the Scottish ministers will have to consider the cumulative and policy position at the time they take their decision. And it may well be that a hearing session on these matters in December of this year, that come 2026 or the beginning of 2026, there have been changes in relation to the cumulative impact and indeed changes in relation to the policy impact. And I'm thinking in particular that Local Development Plan 3 will be coming forward during that time scale. So I do question having such long gaps between the hearing sessions on landscape and policy and the sessions in relation to the matter we're considering just now. And I would suggest it'd be more appropriate if there's going to be a timescale of perhaps a year that we have the sessions together rather than, or one after the other, rather than having to come back perhaps in a year's time to relook at the policy position, to relook at the cumulative impacts and how that impacts on landscape and other matters. So the council do have a concern in relation to having these large gaps and perhaps this decision not being taken for a year or so.
Thank you,
Second, just on another point, we've not seen the letter or the joint letter from the MOD and the applicant. That we don't seem to have been copied into that. And I understand it's not up on the DPEA website yet.
Mr. Hardy, on that last point, have we?
Well, you can certainly have it. There's no reason, absolutely not. We'll copy you into all of that correspondence if you've not had it.
Sorry, sir, just for the avoidance of doubt, I don't understand it to be a joint letter. Nothing returns on that.
That's what I was going to question. Right, okay, thank you. And Mr. Armstrong, thank you for that. That's helpful. You probably sense I share concerns about the protracted nature. Obviously, the baseline never stands still, but the bigger the gap, the more problematic that might become. Mr. Barker.
It's a process question, if I may. Having listened to what Ms. Crawford has said about the MOD's position, I'm starting to understand that there's potentially an issue in relation to national security associated with this planning proposal. Could it turn into a situation where there is an issue associated with national security? At what point does this process cease to be the relevant one and we have to move outside process and in a way that is not public? Procedurally, what happens there?
It doesn't cease to be relevant to this process is the simple answer. So it is this inquiry process which will make a recommendation to ministers, and then it'll be for ministers to determine the application. Mr. Hardy, please. We've obviously covered a lot of ground there. Can I have your
yes? There's a lot of points. There's Birchall leaving. Right. First of all, in terms of timescales and the point raised by the council, it's not unusual, and policy does change, of course, regardless of this sort of issue. And what's happened before, where there have been gaps, is the possibility for an update hearing session, or morning, or indeed for those things to be dealt with by way of written representations. I'm thinking particularly of the new national policy statements and matters like that, and that worked perfectly well. So, yes, there is a concern, but one that I don't think can't be managed. That's the first point. Second point seemed to be about sort of fairness, and the point was raised, well, look, this is just the applicant, and if anybody else came along to this procedure, then they'd be given short shrift. Of course, these things happen all the time. And I'm minded to think of Glasgow Prestwick Airport, GPA Craig Modi. They took a year because they said we're not ready in relation to we need to change our or think about our position, in relation to the Sanka 2 decision. So not the applicant in that case. That was GPA. Procedures were left, very extended in order for GPA to gather its position, and the inquiry sessions for those happened at the start of 2024. So it isn't us just this case and the applicant seeking a unique exemption. Third thing, in relation to evidence, can you proceed in December? In our view, you can't, because if you were looking at imposition of a suspensive condition, you'd have to be satisfied that there was at least greater than nil prospect of that happening. And that is going to involve, now there's disagreement on that. I strongly suspect the MOD would then say, well, no, suspensive condition you can't have. We would say it is. You then get immediately into that evidence. If you are going to have that debate, in our view, that has to be heard properly and has to be heard outside of a hearing session. It's got to be subject to more greater rigor than that. Fourth point, this is a very different proposition to Foresight. There was a let's just put this in context. Eskdale Muir is a very substantial constraint in terms of meeting national renewable energy objectives. Of course, it's an important facility. None of that is contested. But it's important that the dual objectives are met and enabling renewable energy generation to take place. So it's a serious matter. Foresight, that was one type of solution, and that was looking at the algorithm. And the decision of the ministers was as you know. This is a completely different physical type of mitigation. And whilst it is innovative, there is good provenance to that. It is a solution that's been based on scientific evidence from existing BGS seismic assets in Scotland, and also coupled with experience gained at existing primary arrays within the IMS to deep seismic boreholes in exactly the same way. So this is not just applied to fancy. This is something that has good empirical provenance. So bring that forward to give you enough confidence in the in what's being proposed and the MOD to have time to look at that. We are suggesting 3 months of data that is being collected now. So in terms of timescales, we don't think it would be a year. I think it's easy to I heard that I think it's proper to say a year. I don't think it would be that. We were suggesting June. There is a possibility of bringing the pre-inquiry meeting forward. I was only suggesting March because that was a matter that I proposed on the pre-call this morning. But actually, you could have an advanced PEM just in relation to Eskdale Muir in end of January or February. By that stage, we will have the data. And it will then be a question of setting out the timescale for how that is analysed and how the MOD take that forward. So I think there's a little bit of a danger of a sort of scare of going, oh, well, it's a year and open-ended. It's not. We think it's shorter than that. Clearly, there has to be a guillotine on that at some point as well. We are saying that we think by June you would be in a position to have an inquiry session. But the sensible and proportionate thing to do would be to have an advanced PEM, sometime in Q1 in 2025. So overall, procedure has to be fair to the applicant. It's not just fair to the objectors. It's got to be fair to everybody. This is a matter of considerable importance, and for you to hear the evidence properly to give you what you need, I stick with the proposal of an inquiry session rather than the hearing session, and to put an advanced PEM in Q1. The final point I make is this: if that you hear all of that and you go, well, actually, all right, I'm persuaded about that, Mr. Hardy, but I'm concerned about the gap. Then that we would not object to setting the inquiry sessions back to June, 2025 in relation to landscape as well. As we understand it, it is only L&V that will have an inquiry session. There are then hearing sessions in relation to policy and the and anything else that comes on that list. It will fit within a 2-week envelope, so it's not going to extend the amount of time that the inquiry was scheduled to take in the first place. But if you felt that that gap was unattractive, then we would not be averse to you putting the inquiry sessions back for the other topics as well to match the Eskdale-Muir. I don't think you need to do that, but that is an option.
Thank you. There's a lot in that. It's a question you won't be comfortable answering, I suspect, because it's not down the route which you're advocating. But if I was to proceed with on the basis that actually it's the inquiry will proceed in December, and I'll consider all matters and the evidence available to me. If I was to do that, what procedure would be appropriate in terms of Eskdale-Muir?
It would have to be evidence and inquiry, and what you'd end up with is half the evidence, because we would have, and I suspect at that point it would be the MOD then saying, look, this isn't fair, because the data will be available. It might not have had time to process it, but on a matter which is going to be clearly of interest to ministers in bringing forward what we say is a solution which could actually unlock the potential for renewable energy generation in this area. You've got it. They will want to know about it. There'll be the data there, but the MOD won't have had time to look at it or consider it properly. And I have to say, we want to work collaboratively with the MOD. Absolutely we do. And I think there is great merit in working together rather than walking straight into a combative position when we don't need to.
I mean, if I ultimately decide to proceed with the inquiry on the December timescale, I wouldn't be allowing the kind of drip feeding of data and evidence through the inquiry process. There would have to be a cut-off when we say, well, that's the evidence that's being presented, that's the case. And then if something materially changed, that would be for you to submit as and when that was available. And I would have to consider how to handle that in those circumstances. So we can't have a kind of iterative process of
no. Of course. The difficulty with that is that within this timescale, then, and I strongly suspect this would be, I can't speak for Ms. Cook, but I strongly suspect this would be unattractive to the MOD. They will then get data, they will get an expert, but they won't have time to analyse that, and that's not going to help anybody. So in that situation, the unfairness, I suspect, in December would actually be on the MOD, because we'll put forward data, won't have time to analyse it. It won't really help you because the experts haven't really. It just, with respect, doesn't feel sensible to try and deal with an issue that needs to be aired properly, fairly, proportionately in December, come what may.
Mr. Mundell, I can see your hand up. I would like to just come back to Ms. Crawford on this point first, please.
Thank you. Mr. Hardy anticipates what the MOD's position would be if, as would seem to be likely by the discussion, there will be some data which the applicant would wish to present to the inquiry. Looking at the timescale, knowing that the data is just now being gathered, it's going to be impossible for the MOD to properly consider that and form a view, and thereafter present that view to the inquiry, so that it in turn can consider whether what is proposed is practicable, feasible, and would solve the constraint which is now represented by the array. The MOD would be very, very anxious to avoid having to react very quickly without being able to properly inform itself of all that was being proposed. And looking at the proposed timetable, working back from the December date, it seems to me that, so I use the word impossible, it seems to me that it would be impossible for the MOD to present its position on the data, bearing in mind that the MOD will be setting out, first of all, its position on the science as presently exists, and then having to form its view on what is being proposed by separate scientific process to mitigate through these boreholes, and whether that would in fact operate to dampen the effect of seismic ground vibration. And it would be very unsatisfactory, of course, for the MOD to come to the inquiry in December and to throw its hands up in horror and say, well, we just can't deal with this. But I suspect that might be the position which the MOD is in. If the inquiry was to consider having an inquiry session in December on the array, based on the supposition that the applicant will be producing its data and its analysis of the data, and the MOD having caught up, perhaps not having gone all the way around the circuit, the MOD would be very resistant to that indeed. I'm sure that doesn't help you, but that's the MOD's position.
So in terms of the MOD's position, do you consider there to be options here in terms of the next steps?
There are options, of course there are options.
Sensible options or attractive options?
Well, I suspect it's the least worst option, noting the applicant's position that it wants to present its evidence that it can mitigate or augment the array. It is innovative, and I don't wish to get into the merits of the matter. Parties are in correspondence about it, but some of the comparators which are being suggested, early stages, the MOD is not convinced that they are proper comparators, and in any event, this is a different location, different seismology, different topography, different geology, and all the rest of it. The least worst option, well, the applicant wishes to present its evidence, and the MOD would be resistant to that being presented at a hearing session. If it were to be at an inquiry session, December is just not practical. And I suppose we go back to the least worst option being the split suggestion outlined by Mr. Hardy at the outset of his comments on the array.
There is, of course, the option which may or may not be attractive to all or anyone around, well, if the evidence is not there to be tested or in a position to be tested properly in December, we don't test the evidence at all on that matter.
Well, there is that, but clearly the applicant's not going to be content with that.
Right.
Sorry?
Yes, that's right. Yeah.
Because the MOD, and again, this will come as no surprise to those who followed Fosside, the MOD in that scenario would be relying heavily on the precautionary principle.
Thank you. Mr. Mundell, sorry, I've kept you waiting a long time there. Thanks for your patience.
No, that's okay. I just don't find, the suggestion acceptable at all. Because I don't think the applicant is like other organisations. We've heard from Mr. Hardy about Glasgow Prestwick Airport, but they're not in control of the timeline for the application. And I think it isn't unreasonable to expect that an applicant would have done, all of the necessary work for the proposal, before moving to this stage. And I think to ask all of the other participants, to ask the communities impacted to wait is for something that is up. I don't want to get into the merits of it, but something that isn't it isn't established. And I think that's also different to changes in policy. Changes in policy are not site specific. Changes in policy are things that are running on their own timeline, their own trajectory, and they come in from outside the process and require a change. This is something that's been brought up from within the process, after the point, at which the process has started. And I've maintained the point, that's not something that would be open to other parties to gather new evidence to improve their case. And I just think it's going to be very confusing. To have it split, and I don't think we could have confidence in the timescale that's been proposed, because I think a change like this will go beyond, just internal MOD discussions. I think this would be a significant departure from established UK government policy, and I think that process will take longer, than's been set out.
Mr. O'Neill.
From the discussions I've heard between the applicant and the MOD, it appears to me that to proceed on the timescale that has been agreed so far would result in best evidence not being placed before yourself. And that leaves me with some difficulty, but obviously the applicants are doing some work to try and produce evidence of this mitigation, but the MOD are saying, well, we would need the time to have a look at that. And if you're going to proceed on best evidence, I would have thought that process has to be completed.
Thank you. Yeah, I mean, there is a question about best evidence and best available evidence, and there's a distinction to make, I think, there. I think we need to take a view today on this matter, and I intend to do so. Mr. Hardy, is there anything you'd like to add before I do so? I might need to take a few moments. We're probably running up to a point where we'd all like a comfort break anyway, so that might be a good opportunity for me to think this over and come back to you all.
Yes, a number of things again have been said, so I'll try and keep the response short. I'm afraid Mr. Mundell's submissions aren't terribly helpful with respect, because these are technical matters, and I'm not sure whether he's aware of the evolution of mitigation proposals at Estelmuir, but actually Community Wind Power took forward what it believed was a mitigation in relation to the algorithm at Forside. So that was a process which, and had that gone in favour of the applicant, we wouldn't be here having this discussion. So it's a, these things are lengthy and complicated. So it's not a case of the applicant not being aware of this issue. Of course it has, but for this particular proposal, in light of the position that was taken at Forside, this is a different type of proposal which we hope will unlock, which will allay the MOD's concerns, but also unlock the potential of this area. The second thing is that there are other examples. I'm sure you will be aware of these, but there's Greystone now, which was a scheme which has been where there is going to be a gap in the procedural timetable. I'm sure you're aware of others as well. It is not unusual, albeit I accept that it is not optimal to have gaps, and there needs to be provision made, in relation to updates. The third thing is, you'll be aware that there is government policy that is ongoing. There may well be announcements in relation to such as Estelmuir, and you would have to have submissions or potentially reopen the inquiry regardless. So the ability of parties to deal with new information and changes in policy is nothing new. For what it's worth, hearing all of those submissions, with respect, it feels to me as though there's basically an agreed position with the MOD, because if in December we would put forward evidence, and we will do that, the MOD is not going to be in a position to respond to an inquiry session. That is not fair for any, that is not going to be helpful or fair for anybody. So I don't think December for an inquiry session is going to work. If you didn't feel that splitting the sessions was manageable with an advanced PEM and potential for an update session in June or July, then it seems to me the better solution would be to have a PEM at that time, but to put the landscape and policy sessions back and hear them at the same time. So you don't take the week in December, but you put the 2 weeks in June or July and you hear them both together. I don't, for what it's worth, with respect, I don't think that's necessary. I think you can make progress and deal with all the other matters and then potentially have updates. But I can understand if somebody was concerned about that gap, then the thing to do would be to put the OMV and policy sessions back to back with the Estelmuir sessions. And I would then suggest we have a second PEM in March or February, it doesn't matter when that is, just to set out the timetable and the run into that inquiry.
It was to have a second pre-examination meeting in the early part of 2025. I suppose I would want that as early as possible.
It could be January. I mean, we're not. I was only absolutely suggesting please don't get fixed on March or April. It could be January is absolutely fine for us as well. That wouldn't matter.
Well, surely we would need to have moved on somewhat in terms of the evidence gathering for that PEM to actually be meaningful in terms of setting a timeline.
3 months data though, that's starting now. So we're September. So September, October, so we get to December, and the data will be available. There is Christmas, but at least at that stage, the data will be, the data will be there. Pressure, I suppose, then is on the MOD to decide in a preliminary way how it deals with that. It may say January is too soon, and therefore February, March is a more sensible timescale to see that we then have that material, and it has at least had chance to look at it to say we will need 2 months or 3 months or whatever it is to analyse it and put our reports together. what I'm really saying is I'm not fixed on, if it's end of January, February, March. It doesn't. Well, I'm not being prescriptive from the applicant's perspective. There has to be a balance struck. But you could have it then, and the data from our side would be available. It would really be the MOD then having time to have a view over it. And Ms. Clough was very fair to me. She said that Dr. Bowers was attending one of the international conferences, which I think it's February, Ms. Clough, or March. So that is absolutely something that has to be taken account of. Dr. Bowers has got other things to do.
Thank you. Let's take a pause here and a comfort break. Ms. Crawford, I was conscious that your availability is somewhat limited now. How long do we have you for?
I can stay until 12ish. I'll probably drop dead as 5 minutes past 12, but 12 would be more comfortable.
Okay.
But Mr. Milne is present and can take over from me. And please, by leave, if you sir are still speaking, I just leave. There's no disrespect intended, Mr. Milne.
Absolutely no problem. No, that's fine. Thank you. Okay, I would like to pause here. We'll take a break until 10 to 12. Please stay on the call. You can mute yourselves, you can turn your cameras off whilst we're having a break, but please do not leave the call, because otherwise we'll have a protracted process to get restarted. So I'll see you at 10 to 12. Thank you. 50. Can I, if you could all put your cameras back on so I can see you're back at your desks, that would be helpful. Yeah, thank you. That's everybody with working cameras, I think. So yeah, there's a lot to reflect upon in those few minutes. I was reflecting on it, anticipating what might be coming forward today, last night as well. So I've had some time to think this through. So I do have some sympathy for the applicant's position when putting the case on hold could give an opportunity to potentially overcome the MOD objection. I'm not clear on the likelihood of this, but that's a separate point, really. Now, whilst I'm not legally obliged to follow the Energy Consents Unit's request for the inquiry to proceed to normal timescales, based on the evidence before me, ECU is effectively the client here who has made the instruction for an inquiry to be held. So I can't disregard ECU's position lightly. There are other considerations too. I've already said ministers and also the courts expect inquiry processes to be held expeditiously. And I am concerned about the rather open-ended and uncertain nature of this matter as it stands right now. The purpose of the inquiry process must also be borne in mind. It's not to try and reconcile disagreements or to find compromises at this stage of proceedings. It's to consider whether the proposal before me now would be acceptable on balance, or if it could be made acceptable through the use of conditions, for example. And it's my role to advise ministers accordingly. So it's the end of the planning process, essentially, when unresolved disagreements are brought to a head. I'm conscious of what others have said as well. A further layer in my consideration of how to proceed are the wider implications of any delay. So from a very kind of narrow, kind of inward-looking perspective, the DPA is anticipating an unprecedented increase in both the volume and complexity of cases in coming months. And that's indicated in our recently published annual report. Now, I have the capacity to run this inquiry now, and that might not be the case in several months' time. And this could result in additional delays for this case, as well as diverting me away from other casework. So I need to keep that in mind. And for other participants, delay may also mean that matters which are considered in December might need to be revisited, and that would be far from satisfactory from their perspective and from mine. However, bringing all this together, I intend to hold the inquiry in December for all matters, but excluding Eskdalemuir from that. I will then hold a second pre-examination meeting on the matter solely of Eskdalemuir, and I want to hold that in mid to late January 2025. I wouldn't wish to put that off any further. At that point, I'll take a view on how I intend to proceed with the matter, whether an inquiry can be accommodated, if indeed it's needed, whether that would form part of a single report to ministers in terms of my own findings, whether a supplementary report should be considered, or whether the timescales will be too protracted to accommodate. But I am willing to put that to reserve judgment on that until January 2025. I can see a hand up, so I can't see who it is. Is it Mr. Hill?
Aye, that's right. It's me. Just to apologise for having to leave the meeting. I thought it would be appropriate and polite just to say to you thank you very much for the invite. I look forward to Ms. Devoy giving me further correspondence towards any other meetings that will take place.
Thank you. That's no problem at all. Thank you for your participation this morning.
Very enjoyable. Thank you.
I realise as well, ladies and gentlemen, I had my camera off as I was providing that ruling, so apologies for that, but I've just been made aware that I was invisible to you all, so I hope that didn't cause any difficulties in you hearing my ruling on that point. I'd like to just give an opportunity for the applicant and for the MOD to comment on what I've said if they wish to. Otherwise, we can take it as read and we can move on.
Yeah, thank you very much. That's very sensible. I've got nothing further to add.
And
Ms. Crawford.
Nothing on my part to add either.
Thank you. And Ms. Crawford, if you do need to escape now, then you're very welcome to. Thank you.
Thank you very much.
Ms. Bruno, I can see your hand up.
Yes, just to say that I think that's a great conclusion that you've reached, Mr. Warren, because it was a difficult decision to come to. I just wanted just to say that we all of the other bodies had to put forward, the information by a certain deadline, and to drag it out even further, I think is impossible for all of us, because we're all very busy people actually as well. So I recommend your decision. That's all I wanted to say. Thank you.
Thank you. That's helpful. Okay, I shall move us on. Now, I mentioned in in my lead-in to the question of Estelmuir and the MOD objection, my thinking potentially around taking a similar approach in terms of a conditions hearing to think about how the NAT safeguarding objection could be dealt with. Hopefully this won't need quite as lengthy attention as the last issue, but perhaps it will. I don't know. So if I can perhaps come to Nats first, and then I'll come back to the applicant, please.
Yes, good morning.
Mr. Rossi, thank you.
Hello. Yeah, so no, yes, from our perspective, hopefully the Nats position is a lot simpler. So we've identified an unacceptable impact due to the radar detection. And the MOD will correct me, but I understand their two objections, or their two grounds for objection, are completely unrelated to the NAT position. So notwithstanding the objection, we've identified mitigation measures. So we're quite satisfied there is a technical solution available. And I understand from my colleagues we're in advanced negotiations with the applicant. So from our perspective, I think conditions would be appropriate.
Thank you. Okay, Mr. Hardy.
Yes, I can confirm. Advanced state of negotiations, there will be an agreement. There will not be any requirement for procedures in our view, and that will be that'll be wrapped up in a condition.
Okay, thank you. That sounds clear, and there's agreement on that point. Of course, if that situation changes, please do keep me.
Of course, I'll let you know.
Thank you.
Yeah. Just sorry on that. Is there any further need for NAT at all, or obviously
in terms of this meeting, Mr. Rossi?
Yes.
There's only the question around timescales. You've seen my indicative kind of timescales in terms of where a conditions hearing would fit in. I'm looking at the second week of December. As long as that doesn't cause you any major problems which would need further discussion, I'd be quite relaxed if you have other things you need to be doing.
Yeah, no, that's fine. As far as NAT is concerned, we'd make someone available if there was a hearing, and that wouldn't be a problem at all from our perspective.
That's helpful. Well, thank you very much for your participation. It's appreciated. Thank you.
Thank you very much.
Okay, so it's 12 o'clock and I haven't even mentioned what inquiry sessions we'd like yet. So that's quite something, but we'll come on to that now. So I am actually only proposing one inquiry session, and that's on landscape and visual effects. Now, for this, I would like evidence to focus on the effects of the scheme as amended upon the baseline landscape and visual context, rather than focusing on comparisons with the original 75 turbine scheme. I appreciate there will be some reference back to it, but that shouldn't be the focus. I'd anticipate that this session would include evidence on the effects on the regional scenic area and wildland, receptors in the surrounding area, including Moffat, Annandale, the Dry Water and Wanfrey Water, and visual effects from residential properties and recreational routes. That's not an exhaustive list, but they're matters which I'm keen that I hear evidence on. I've not reached a firm view yet on how nighttime or dark skies effects from aviation warning lighting should be best considered, whether this ought to form part of this landscape and visual inquiry session, or whether a separate hearing session might be more appropriate. You'll have seen that I'm currently leaning towards the latter, and a separate hearing session, as indicated in the annex to my agenda. So I'd like to hear views on this. And I suppose it might, to a large extent, depend on who will be intending to participate on the topic of nighttime or dark skies effects, as to whether a hearing would be a more appropriate or preferable option to incorporating that within the landscape and visual elements. So you can see hands raised. It's helpful. Mr. Patterson, please.
Sir, I'm currently starting a written submission. I can give it either as an oral presentation or later on if you feel like it. But I've certainly got some written submission to make.
In terms of the submission, what's the nature of that submission? Is it the impact from lighting that's your...
The impact from the lighting of the aviation units, yes.
So, okay, so in terms of today's proceedings, there won't be an opportunity to talk about the merits of that or the impacts of that, but purely what I want to focus on now is the process for accommodating that. So from what you've said there, you're keen to be involved in some process depending on which we kind of take. Would that be a fair summary?
I can accommodate whichever way you want to work.
Okay, that's helpful. Thank you, Mr. Patterson. Right. Oh, yeah, Mr. Smith. Thought I had a second hand up.
Yeah, I feel very similar to Jim Patterson there. It can be handled either way. It's got certainly merits to have it on its own, but it is unavoidably linked to tourism and is one of the future growths of tourism and therefore the landscape. So I suspect that you would probably be wiser to put the two combined.
So put the nighttime effects with the tourism effects and potentially something wider, given what we discussed previously in terms of community concerns.
Yes, I would suggest that.
Ms. Wingfield, please.
Thanks. Certainly from the perspective of North Milk Community Council, we are very keen to be able to voice locals' concerns in terms of the nighttime lighting effects of the proposal, especially as it's going into a very, very unpopulated area, sitting very, very high up. So my only concern I can understand why it would be meritorious to lump it together with tourism, but I wouldn't like that joining up to dilute what the community councils would like to offer in respect of their views to do with lighting, nighttime lighting. Thank you.
Okay. Thank you. Mr. Barker, please.
I think I'd like to say that Moffat Community Council, I think, is going to be able to address the issues, frankly, however you decide to format those sessions. I alluded earlier to the fact that Visit Moffat, the tourism organisation, was not active at the time of original submissions, that we have a committee meeting tomorrow, and I will discuss the issue with them. But I think you can be reassured that we can handle however you want to format that, because we do have things to say on each of those issues.
Thank you. Mr. Armstrong for the council, can I ask, would it be the council's intention to potentially lead evidence on nighttime effects?
And it would not be the council's intention to lead evidence on that. The council's position is it will lead evidence on the landscape and visual effects session, and obviously the energy and planning and policy sessions, and conditions, but not this session.
Okay, thank you, that's helpful. Mr. Hardy, could I have your thoughts, please?
Yes, so hearing all of that, our view is that a single inquiry session dealing with landscape and visual nighttime effects and dark skies is the appropriate way to go. Secondary point is in relation, I know we're going to come on to this, but is in relation to tourism. And our view would be that there isn't any requirement or there any utility in having a hearing session on that. And there are reasons why I say that, in particular, the absence of tourism or requirement for tourism assessment in policy 11 of NPF 4. But what I can see is that it's linked to the earlier discussion about a community session, because clearly, I mean, absolutely, we're on the same call. We're hearing what's been said, that tourism is a matter if local residents or local business operators want to raise, then there needs to be a forum for that. Ultimately, what the applicant will say is there's no mechanism to see how an impact on the landscape translates. There's no evidence to indicate that an impact on the landscape then translates into a drop off in tourism. So that's the bit that's missing. If what is being said is that these things will be harmful to landscape character and to visual effects, and that's the limit of it, and then the final sentence is, and that means that people won't come, then that actually to me is an L&V matter rather than a kind of an economic matter. So we absolutely do want to deal with all the character points, all the visual effects. We think we think nighttime and dark skies and all that can all be dealt with together. That will actually pick up those impacts where genuinely there may be a concern about whether or not that would disincentivize people to visit. When we move on to the next point, I will also then say I don't see that in policy terms that a hearing session on tourism is required just to deal with to deal with local business. It seems to me that's a community issue, and that's one if you can have a community session that might proportionately be dealt with there.
Okay, thank you.
Just one final point as well. Can I just say this too, that you mentioned residential visual amenity assessment. There isn't as you know, particular objection in relation to that. That is a particular topic. So I don't know whether you were using that in the generality about that's sometimes what you get. Here it seems to us it's character, it's visual effects, there might be some recreational effects, but I'm not aware of the need to have detailed evidence given on the visual aspect of residential amenity assessment. If so, then we would need to prepare for that. That's a discrete part of the evidence, if you like, and I'm not sure that's required over and above what you've got. Mr. Welch, as you know, is instructed to deal with all of these matters. It's a point of availability. He can only deal with he's only available in the first week. I don't think that's going to be I don't think that's a problem because that's when he like to have the sessions anyway. But he can only do that first week in December.
Okay, no, that's helpful. Yeah, so on the matter of residential visual amenity, first of all, some of this will feed in or out of my further written submissions, I suspect, as well. So you'll have seen I've made a kind of a headline note of some information that I would like to seek. So the need or otherwise to delve into that further during the inquiry session will depend to a large extent on what's provided for that. Yeah. Okay, so Mr. Barker, followed by Mr. Mundell, followed by Mr. Barker, Mr. Smith, Mr. Mundell, please. So Mr. Barker first.
Yeah, Mr. Warren, I have to rely upon your good offices to decide what the correct and best format is. However, I need to stress, which hasn't been stressed so far, that a third of employment in our community is based on tourism. It is a significant employment element and a significant part of our community's future. And I would really appreciate it if the opportunity for the impact on tourism could either be speculated about and discussed at some point, or the potential management of downstream risks of the impact on tourism. I have to rely upon you to format that the right way, but for the local community, it is a huge issue. Thank you.
Thank you. Mr. Smith.
Yeah, in fact, I actually was about to say exactly what Mr. Barker said there. I'm actually, to be frank, quite horrified by the statement by Mr. Hardy, who is not by any means a tourism expert, and to suggest that a little town like Moffat, whose sole dependence is on tourism, it will not be impacted by these things is abhorrent. And I'm holding my breath when I say that because this isn't for this meeting. But I would strongly, strongly, strongly advocate that we do have a tourism element to this, and that we're allowed to even go back, now that we've had this meeting, to say that there is now interest, to be able to go back to our community. And of course, guess what? We'll be scanning 3/4 of our population because they're all involved in tourism.
Thank you, Mr. Smith. Mr. Mundell.
Yeah, I just want to be absolutely clear. I wasn't asking for tourism to be dropped. I felt that community and tourism are so interlinked that they would fit well together and would allow people to voice, the majority of their concerns. And secondly, I'm a bit confused by Mr. Hardy's assertion, and I don't want to kind of get into the policy of it, but I've previously taken part in other inquiries where the applicant has led evidence in relation to tourism and drawn evidence from the bigger economic study on wind farms and tourism. And I think that study does, in relation to this proposal, raise some questions that are quite specific and should be explored. So I think there is substantive evidence to explore that's already out there.
Thank you. I will come back to the matter of tourism specifically shortly. On the matter of the night skies and aviation lighting point specifically, I don't think I want to rule out the possibility of some consideration of that through the landscape and visual inquiry session, but that would very much depend on the participation in that session. Mr. Armstrong the council doesn't intend to leave evidence on that point. If there is particular evidence being put forward on the landscape and visual impact of aviation lighting, I would pick that up there. However, my intention is to still carry that through into a hearing session, which I think is broader than, strictly speaking, nighttime effects. I think that there are interrelated issues here which are worthy of exploring. So whether or not that's a standalone hearing session with the title nighttime effects, or whether or not it's something broader, as we've been discussing this morning, I will reflect on that. But I'm leaning towards the latter, where we broaden something out and have a session which can pick up on some of these themes that are interlinked: nighttime effects, tourism, and wider community concerns. That might lead us in neatly to Mr. Hardy. You said you had some reasons why a tourism hearing shouldn't be kind of proceeded with, but I didn't give you the opportunity to tell me what those were at that point. So would you like to do that now, please?
Yes. So, I mean, the Moffat study is quite long in the tooth, as you know. That was also pre-MPF4. And what is said, and I don't want to be misunderstood. In fact, I've just spent 8 days going around Scotland on the NC 500, and the impact of, on the importance of tourism, absolutely understood by me to, a number of communities. So it's not coming at it from any other angle. But the mechanism by which turbines can impact on tourism just hasn't been made out over the last 20 years. That's the basic position, and in policy terms, that's the view of ministers as expressed in national policy. I understand the concern, but what it seems to come down to is there will be impacts on landscape character, on visual amenity, on footpaths, recreational amenity, and so on. Absolutely, that, and night skies, that absolutely needs to be understood. I'm not sure what else there is over and beyond that which would justify a hearing session on the mechanism, if you like. How does that translate into lower tourism levels or whatever? And if it's at the level of, and again, I'm not denigrating this at all. I run a guest house, I've got a hostel, I've got a campsite, and I'm concerned, absolutely. But that's a community concern, that's a local concern, which it seems to me can be aired and expressed and weight given to that following if you're going to have a community session. So it's not required in policy terms. Having done in these wind farms for 25 years, I have yet to see a case where, tourism has actually engaged in as a separate material consideration. But you absolutely do need to pick up all the potential impacts and weigh those in the balance, and we're going to do that in the L&V session and the other things.
Thank you. Mr. Mundell.
Yeah, I don't accept that, because I think tourism is related to economic development. The applicant, as part of this, puts forward a proposition that this project will be good, for the economy, both at a national level, but also at a local and regional level. And I don't want to get into the kind of case itself, but the Moffat study and its subsequent follow-up do show some variation in the impact of wind farms in different locations, and there are some examples close to Moffat within that I think should be and are of interest. And I think the question comes down to impact on employment. I think that is a relevant consideration. I think there is substantial evidence coming from businesses and individuals within the community that suggests this proposition put that at risk, and that extends beyond simple kind of landscape considerations. That's about the social fabric, and the economy of Moffat, and I think it's important for ministers to have access to that information to weigh into the balance of whether or not this is the right proposal in the right place, and whether the economic benefits the applicant suggested, will be fulfilled.
Thank you, Mr. Lloyd, please.
Yeah, I'd just like to echo something that David Hardy said about the bigger economic study being long in the tooth. I think if you look at that, you'll find that all the empirical evidence on which it's based are sub 80-meter turbines. Many of those are set back from communities rather further than the ones that have been proposed for Scoop Hill. But of course, Scoop Hill are much, much larger turbines and much, much closer. There has to be a point of inflection here, a tipping point, at which the impact of these are considered to have materially increased at far further rates, non-linearly, than the preceding studies. So I wouldn't hold up the existing studies as being very good evidence for anyone to argue anything about turbines that are closer and significantly larger. The impact of these is unprecedented, and it should be taken as a special case. Thank you.
Thank you, Mr. Smith.
I don't want to labour a point. Mr. Hardy is very clear that he doesn't see tourism as an interest, even though he couches it otherwise. Moffat is different, and you cannot compare apples with pears. Moffat is a very subtle beauty. It's got nothing significant. It's got nothing iconic. It's got nothing that everyone says, oh, there's Moffat. But it has got a rolling hills beauty of it and its surrounds and the quaintness of its town itself. It cannot be compared to other places that have very strong tourism pulls. We haven't got a strong tourism pull. We have got what we've evolved. We've got a tourist package in the town that's evolved over many years, and a very gentle beauty around us and quaintness. You cannot begin to tell me, Mr. Hardy, that this will have no impact on that gentleness and the subtle beauty of Moffat. And it appalls me that you can't keep trying to poo-poo this and push it aside. I suspect it's because you realize, having spoken to some of the people in the town, how they feel about tourism and what it will do to the impact.
Well, okay, thanks, Mr. Smith. I mean, this will come out in the wash in terms of the process that I select. So we don't need to get into the kind of the detail of it now, but I understand the sort of strength of feeling about it. Mr. Barker, then Ms. Bruno, and then I'll reflect on what I'm thinking as well.
Okay, thank you, Mr. Warren. Just not necessarily a correct procedural point, but it seems to me that we have already allowed a variation from process to take into account time for the developer to deal with what are currently negative aspects relating to Eskdale-Muir, and due consideration is being given to how they may be mitigated. And you yourself mentioned the possibility of conditions being applied. It seems only reasonable to make the same allowance for consideration with the possibility of conditions or whatever else through the issue of the subject of tourism.
Thank you. And Ms. Bruno.
One of the reasons that our community objected was because this particular wind farm proposal is so close to the community and is absolutely visual. And most wind farms along the M74 corridor are not visual by their communities. However, Scoop Hill is different to that, and that is why we have a real concern regarding the tourism impact on the economy and the community, and that is why it needs to be looked at, because as Mr. Smith was saying, we rely very heavily. BSIC does as well. There are people in our community that work in Moffat and work in the tourist industry. So that is the reason why it is so different, and that is the reason why it is important to address differently, because we will actually be surrounded by the wind farm on this occasion, which we haven't been done so in the past up until now. Thank you.
Thank you. Mr. Lee, you've got your hand up. I'll come to you, and then I'll speak.
May I speak, Mr. Warren?
Please do. Please do.
After the gentleman has spoken, can I just say a few words?
Of course.
Thank you.
Would you like to speak now? Sorry, I misunderstood you.
You know, I'd like the gentleman the gentleman that you requested to speak. I would appreciate if you'd let him go on.
No, there's nobody else speaking before you now, so you can speak.
Oh, thank you. Sorry, Mr. Warren.
No.
I've got it all wrong. I just want to put the spotlight on dark skies, and so that there is obviously taken as a separate issue in relation to the national, international, because it's a special case in the world. Thank you.
Thank you. And sorry, that was Mr. McClyman, wasn't it? I was
Yes,
confused.
sorry.
Sorry, I'm causing confusion now, so apologies. Mr. Lee, you have your hand up. Right. So you're muted, Mr. Lee. That might be where pictures are too small to see. Lips moving sometimes, aren't they? I can't hear you, Mr. Lee. It doesn't appear that you're muted, though. We know your computer works because we've spoken already. Can you give me a thumbs up or down? A thumbs up if you were wishing to speak, Mr. Lee. You are wishing to speak. You just need to work out the microphone. On the Mr. Lee, I can see that you can hear me. If you can see on the top bar, assuming you're using a computer, if you can see on the top of the screen, there's a little picture of a camera. It says camera and mic. I don't know if you could click maybe the mic button. Although, as I say, it's not showing you as muted, but I can't hear anything, I'm afraid. Sorry, Mr. Lee, I can't. Yeah, I'm not going to be able to help. I don't know if you can see. We do actually have the fallback position. There is a chat bar. I don't know if you can see that. I don't mind you if you'd like to briefly type a question into there, and I can come back to you on that, and I'll speak whilst you're typing, if that's possible for you. I'll leave that with you, and it'll ping when you put something in. Okay, and I'll come back to it. Okay, so there's a lot again to reflect upon there. The thinking about our earlier conversations at the start of this morning about the appetite for a community session, I actually think that rather than two separate titled compartmentalised sessions on dark skies and then tourism, rather than that approach, I am attracted to a wider, kind of broader church discussion around, okay, what are the local concerns, and have an opportunity for people to be involved in that session over the course of a day, I would suspect. I do need to give more thought to precisely kind of what parameters would be put around that. I am attracted to the sense of it being a hearing session in the more conventional sense, because that just allows that discussion, that challenge, and those counter arguments to be articulated by everybody. So it's as fair and non-prejudicial process as possible. that's got the benefit, though, of unlike an inquiry session, as I say, where participants would be cross-examined, the questions would be led by me. Questions can still be asked of other parties through me, but I would have control of those proceedings. So for anybody who's kind of less comfortable and with such a process, I can give you the sort of reassurance that I will manage that to try and make it as comfortable as possible for you to participate. So I will give thought to precisely kind of the parameters for that in terms of topics. What might be helpful, though, in kind of guiding me on that is if I could ask for perhaps submissions at the time, and I'll come on to kind of the deadlines in terms of confirming participation. But when I ask for participation, if I could have an indication, particularly from individuals and the community councils and Save Our Hills Moffat, as to what you would like to see the parameters of that session be, that could be something I could then work with, and I'll finalise a agenda in due course to shape that session. Does that sound like a practical way forward to everybody?
It does, respectfully. Can I just raise a couple of points, and they are following on from that, just so that we are able to prepare for that, an understanding of the scope of what's going to be discussed. And I think that'll be picked up in the point that you've just made. Secondly, Mr. Lees.
I'll come back to that. Yeah, please continue, Mr. Hardy.
The second thing is that Mr. Welch would want to deal with the dark skies point, and therefore can I suggest that we have that in that first week? And actually, jumping a long way ahead, it seems to me that still works actually within a week, because we're going to suggest a day for us and LNV, a day for the council, so 2 days for LNV, 1 day if we're going to have this sort of community issues, and then half a day for policy, half a day for conditions. So it seems, and that just as a broad time scale. I know that's jumping ahead, but it feels to us as though that would fit with Mr. Welch's availability, because he would need to be there on the Tuesday, Wednesday, Thursday.
Yeah, thank you. Yeah. I mean, I've got half an eye on the kind of timetable as well from that perspective, and I'm confident that we could accommodate that session, that hearing session that I've just mentioned, within the first week. That would be my intention too.
Yeah, perfect.
So I'll just go to the chat bar. So just bear with me a moment whilst I read. So Mr. Lee said, I wish to highlight the community subject. Government policy suggests community voice should be heard. Community concerns go beyond material considerations, but encompass well-being, quality of life, etc. Can we consider community as a subject in itself? Hopefully, I've just answered your question then on that basis, Mr. Lee. And I'll say we'll have a hearing session with the scope of that to be kind of finalised in consultation with yourselves. So I shall hopefully address that point for you. I appreciate it's not easy for you to respond to that. Thank you. Okay, thanks for that. It's been very helpful. So moving on, in terms of other hearing sessions, I've suggested 2 further hearing sessions in addition to the community session, which I've just referred to. So this would be energy and planning policy, and then a conditions hearing session as well, and that would pick up the NATS objection there if that's still unresolved. Now, I intend to ask for further written submissions on various matters which are outlined in Annex A to the agenda. Now, my intention is that I would include these detailed requests in my note of this meeting. So that would be essentially the procedure notice to trigger the requests for those submissions. And insofar as any of these requests may be kind of construed as additional environmental information, my view is that Regulation 20(6) would apply, meaning that separate advertising isn't required outside of this process. There's the additional matter of wind stealing or wind theft, which has been raised in various representations. And Dr. Lloyd, you've queried whether this would be addressed as part of the overall inquiry programme. Now, it's not a matter for which I was intending to hold any further procedure, as you'll have seen from my draft that I've shared. But as with any other matters, that's very much up for discussion. So I'd like to listen to views on this matter, but confined to process rather than kind of the substance of any arguments. So if I may, Dr. Lloyd, I'll come to you first, please.
Yes, I think it's really important to recognise the unprecedented scale of these turbines. These are not the same turbines. Something just because it looks the same, when it's much, much larger, its impacts are going to be quite significantly different. And we can see that in some of the seismic concerns and the frequency of the seismic impacts that are being considered at the present in a different section. In this particular case, the only turbines that approach anything like this scale appear in seaborne studies, and they have already been measured at having wakes of 100 kilometers. A 100-kilometer wake means, of course, it impacts the operation of all the existing turbines. And Dumfries and Galloway, as you know, has a very long history of turbines and a large array of turbines spread across the area, certainly within the 100-kilometer range. So it seems really important to recognize that when you take an estate which is consisting largely of sub-80-meter turbines, and you put something that's somewhat upwards of 230 meters on top of one of the larger hills, you are going to put large numbers of arrays in the shade of that particular turbine. Now, of course, that means the wind that is being extracted at that new point was being extracted already by the other turbines. And whilst that is possible for Scoop Hill to show an accounting return in terms of energy extracted, all of the other embedded turbines with all the concrete, steel and carbon footprint and all of their environmental payback calculations are suddenly confounded by the imposition of a new, much larger installation at their edge. So I think this is really critical, and it echoes also some of the sound issues as well, because of course, if you take away the sound limit, you take away the sound ceiling, and you take away wind energy, then you're really chilling any further investment in the existing turbines. And we're already starting to see them renewed. Hexshaw Hill is very, very efficient, twice as much energy, half as much in terms of number of turbines. We'll be stopping all of that from happening if you allow this to proceed without taking into account the wind that is stolen in the environmental impact and carbon calculations. So absent at the moment.
Sorry to interrupt you, Mr. Dr. Lloyd. Yeah, so in terms of kind of how this should or could be explored through the inquiry process, what's your view? I mean, I appreciate. So essentially, the options going back to the kind of four main options. There's an inquiry session, there's a hearing session, there's further written submissions. There's no further procedure, which evidently isn't going to be your preferred option here. What are your thoughts on that?
Ideally, I think it's an important thing to put forward and to cross-examine. So I would be happy to see that at the hearing session or an inquiry session. I have no particular preference for whichever the other parties would like to consider this in. But it is such an important question because it directly affects all the promises of the last 30 years of operation, which are trying desperately to make a contribution to improve Scotland carbon footprint, and that can all be set back by not considering the impact. This doesn't mean that large turbines aren't important, but just not on the edge of an existing turbine field. They would need to be put somewhere new, and that gives us energy security and more energy and lots of good things. So I'm not opposed to large turbines per se. I'm simply opposed to putting them in without considering what the net impact is going to be on the environment. So that's quite a complex set of issues, and that needs to be given a reasonable amount of space to discuss it.
Thank you. Mr. Hardy, please.
And we don't accept that. Obviously deal with turbines on and offshore, and the evidence, I think, has been overstated by Mr. Lloyd, but he's obviously entitled to that view. It is a local, it's not a matter of national policy, it is a concern of his. I would suggest that we deal with that if we're going to have a hearing for the community issues in that forum. So it certainly doesn't justify inquiry. I think it can be dealt with in writing, but if he wants to have that dealt with orally, then to deal with it in the.
I just lost you at the last moment of your sentence there, Mr. Hardy.
No,
sorry.
I just drew a breath because a message flashed up on my screen saying that the gentleman who put the message up, I think it's Mr. Lee, was unable to hear anything that was going on. And that was obviously concerning to me. I don't know whether you saw that message. So Mr. Lee,
right, yes,
Mr. Lee flashed up a message to say he was having problems and was unable to hear. So I didn't want to continue.
Right. Okay. It appears, I think Mr. Lee's left the call, actually, by the looks of it.
No, he's still on my...
Is he?
Yeah, I can see. Is that, if this is Mr. Terence Lee, I can see Mr. Lee.
Sorry to interrupt, sir, but it's Liam O'Neill. Liam O'Neill who said he's having problems with the speaker.
Yes.
Mr. Lee is still following the meeting, although he can't speak to us.
Right.
Okay. I shall, in the background, ask David to explore that further as well whilst we continue. I'm afraid it's sometimes the nature of some of these meetings, but yes, it's helpful to know that. And if David, if there's either yourself or anybody in the office could assist, that would be much appreciated.
So just to finish just to finish the sentence was to say that no, we don't think any further procedures are required, or you do that in writing. But if there is going to be an oral position, then it would seem to me that could be slotted into that the hearing session. What we would need is advance notice of any technical report or assessment that is going to be put forward, because it's got just a little bit of a flavour of there's some scientific evidence that's coming forward in relation to weight losses, and actually we would need to look at those and have somebody prepare a report in rebuttal if required. So advance notice, but slot it into that day that we're going to have our hearing.
Does anybody else have anything pressingly wish to say on that matter? I've heard the two sort of views on that, but is there anybody else? Mr. Barker? You're muted, Mr. Barker.
Sorry, I think the issue of the economic effects of wake is not a community matter. It should be considered outside of the community issues. It's a subject in its own right. Thank you.
Mr. Lloyd, very briefly. Sorry, Mr. McClymont, yes, please go ahead.
Yes, and on the subject of weight, I do have a YouTube video, which of course I would like all parties to see, but obviously particularly Mr. Warren. So I have would like to submit a YouTube video on the subject of weight. And that, with your permission, sir.
Okay, well, I'll come back to that in a moment then. Thank you. Mr. Lloyd, Dr. Lloyd, apologies.
Yeah, I just wondered if it's possible for me to quickly come back. I think that Mr. Hardy's position raises two sort of opposing positions. One is that there is no issue, and this is not an issue that is contended, and yet a requirement to respond to a technical issue should that technical material become available. I'm perfectly happy to meet a deadline for submitting any technical arguments. I think he recognizes that this is a real effect, that it is significant. And remember, again, you're talking about 250 meters against 80. To argue that that is not going to have a significant impact on turbines that are directly adjacent is simply not sound. And I think it's unfair to present this as something that is somehow fanciful.
So I didn't say that. What I am saying is that if there is going to be, there's going to be evidence of a technical nature, we would need to see that. What we can't have is just somebody turn up at a community session and raise points of a technical or pseudo technical nature. And finally, if the suggestion is that somehow it's denigrating that as just to deal with that as a community issue, you could stop the community hearing and then have a separate session in relation on the same day in relation to wake, if that's what you felt was justified. So I don't mind. I just don't think it it certainly doesn't require an inquiry, and I'd hope that we could slot that into that day that we've got.
Okay, thank you. Okay, I've heard the different views on that. My intention, I think, having listened to what's been said, is in the first instance at least, ask for further written submissions on the matter where those technical submissions can be provided as well, Dr. Lloyd. So then that would then give the applicant an opportunity to respond to that more fully as appropriate. I will then form a view as to whether or not any further procedure would be necessary. I'm not attracted to the idea of it appearing in the community session purely because even at the best of times, technical evidence is quite a difficult thing to get under the skin of in a hearing session. I don't think that's the appropriate forum for it. So I'll add to the further written submissions that I've indicated, and I will ask a question about this. And then on Mr. McClymont, your question about submitting a video, what I would say, yes, we can accommodate that. We'll have to just think about the format, but that's a technical point really that we can discuss with the office in terms of how we receive that. In terms of how we would make it possible for other people to be able to see that, and for the applicant to and others to potentially comment on what it shows, we would then we would publish that on the Public Eye website, which is our webcasting site. We've done that before with kind of video content, so we could do that so it's available to everybody. Okay. So yeah, so we'll proceed on that basis. Okay, so my suggestion, Dr. Lloyd, sorry, would you like to come back?
Yes, sorry, I just want to clarify because I'm thinking about our earlier conversations preceding the meeting when you said that this would be within the hearing session, presumably energy policy and planning policy. Are you now saying that you don't intend to include it in session 4, or you may include it, or you may hold a separate session depending on what you consider the results of the exchanges between myself and Community Wind Power arise, or what arises from that?
Yeah. Okay. On the subject, sorry if I wasn't clear. On the subject of wind stealing specifically, I will ask for further written submissions on that point. My expectation at the moment is that that might be sufficient for me to further my understanding sufficiently to advise ministers on that point. However, if that's not the case, I will then reconsider whether a further procedure is needed. That may be a hearing session. If I have a hearing session on that, then it will be dedicated to that matter. I don't wish to put it in with any other subject because I don't think it's an appropriate fit. So that's my intended way of proceeding on this subject. Okay. So in terms of other matters, there would not be any further procedure for other topics in terms of oral procedure. I've set out in terms of further written submissions in Annex A various matters that I intend to ask for submissions to be made. Has anybody got any comments or questions about those specifically? If not, we can take them as read at this point, and I will clarify what they mean in my note of the meeting. Ms. Williams, please.
Thank you, sir. I noted that you were asking for further written submissions on ornithological impact.
Yes.
I just wonder if ornithology might also be brought up as part of the community session, given that the unique situation in Moffat with the reintroduction of the golden eagles, it means it's not unrelated to tourism and socio-economic issues. What I'd just like to give notice to Mr. Hardy of is the fact that, as far as we know, there's been no attempt on the part of the applicant to consult with the local experts on the important aspects of the golden eagle population, which is a requirement of the Scottish Government's onshore wind policy statement, where it says that for the resolution of the balance between energy mix, climate change, mitigation efforts and biodiversity interests, it requires careful discussion and planning at a local level. The South of Scotland Golden Eagle project are definitely the experts and they're local.
Thank you, Ms. Williams. I'll ask Mr. Hardy if he'd like to comment in a moment. In terms of the scope of the community session, which I'm envisaging, I think my personal view is that there is scope to bring the generalities of ornithology and those interactions with tourism and so on into that session. Technical kind of points, as I said before, that's not the place for that. The focus of my request will be around some of the specific points that have been made by Nature Scot and RSPB Scotland, in terms of where they maintain some concerns around aspects of the proposal. And I'm going to seek the applicant's response and clarification on certain points on that matter. Mr. Hardy, is there anything that you would like to say in addition?
So the applicant has agreed to update the OH-MEP. As you may be aware, that would cover the RSPB outstanding concerns. We don't think anything further is required. Similarly, Nature Scot got their issues in relation to adequacy of the OH-MEP. So that's our position. We don't think anything further is required. Clearly, just from what you've said, you think that something further in writing might be required, or although it may be dealt with. It may be dealt with by way of updating.
It might be.
Yeah, exactly. So beyond that, no.
Okay, thank you. OH-MEP, Outline Habitat Management and Enhancement Plan.
Yes, correct. Sorry, that's an acronym. I should have explained that. Yes, absolutely.
That's fine. Okay, thank you. I'm very conscious we've been going for quite some time, and it's been quite an intensive meeting for many of you. I suspect we've actually covered the real kind of hard ground now. But I would like to just check: are people happy to continue now, or would you prefer a break for lunch and for us to resume this afternoon? If you don't wish to continue now, please just tell me that. Otherwise, I'll just continue and get us through.
Happy to continue.
Okay, that's consensus.
Can I just say, as close to 1 o'clock would be good, but obviously we've got quite a lot of things to deal with. If we get to 1 o'clock and we haven't finished, then if we could just take 15 or 20 minutes, that might be helpful.
Oh, that's fine. I might be able to do 1 o'clock. Let's see. I don't want to rush anybody.
No, we don't want to rush it. No. I'm not suggesting that. Yeah.
Really, that's great. So in terms of agenda item 5, it would be kind of helpful to know who is likely to want to participate in each of the inquiry and hearing sessions, assuming for now that these remain as suggested in Annex A, and with the amendments that we've talked about. So essentially, the hearing sessions for nighttime effects and tourism won't be under those banners. It'll be a wider session. So I'm conscious, as we've touched upon, that there's potentially several individuals intending to participate in kind of one or more of those sessions. I think there's certainly some scope for all or some of you to work together on certain matters. So that's obviously attractive in the sense that it reduces the amount of inquiry or hearing time that we need to dedicate, and I won't allow repetitive evidence to be given. So it's a case of being able to focus that evidence as effectively as possible. But that's a matter I don't need to know now what if any groups are going to form, but it's just something to keep in mind as we go forwards. But if we take each topic in turn, in terms of the landscape and visual inquiry session, I'm obviously expecting the applicant and the council. Is there anybody else or any other groups that would wish to participate in that session, in the landscape and visual inquiry session? Mr. Mundell.
Yeah, I would be interested in participating in that, because I think that there are some questions to be asked, and I've done that in previous inquiries and found that useful.
Okay, thank you. No, absolutely. No, yeah, you're very welcome to participate in the session. Sorry, I can't see the order that hands have appeared. Got Mr. Patterson with a hand up, so I'll come to you first. Apologies, I know that's out of order now.
Mr. McClimate would like to speak as well.
That's helpful, thank you. With Mr. McClymont first. Mr. McClymont.
Yes, I'm not sure how the hearing session. I would like to be participate possibly in the one you have just suggested.
In the landscape and visual inquiry.
Yes, please. If I could just put my name down.
Certainly.
Participant. Thank you.
Thank you. Mr. Patterson, were you wishing to speak as well? You're muted, Mr. Patterson. There you go.
Thank you. I do wonder, though, if perhaps the dark sky is part of environment impact assessment as well as being technical at the hearing stage. I'll be guided by you in whichever way you would like to put it. But I do have a technical appreciation of the lighting that I can submit.
Thank you. Yeah, I would. I can't guide you on that point. It would be for you to decide how you would wish to participate ultimately. But hopefully, I'll try and reflect in the note of this meeting kind of the content of each and the potential scope, and then you can decide how you would wish to kind of fit in with that process. I think that the landscape and visual inquiry session has the potential to have a technical element in terms of the landscape and visual effects of lighting. But there's clearly a broader point that we've talked about already in terms of it might be the hearing session, the broader hearing session is a more appropriate forum, as long as that's not technical evidence that's being put forwards. Mr. Barker, please.
It's quite likely the Community Council from Moffat would like to contribute in that session. Thank you.
Thank you. Ms. Wingfield, please.
Thanks. I echo Mick Barker's point of view. With my North Milk Community Council hat on, we'd welcome the opportunity to participate, please. Thank you.
Thank you. And Floyd, please.
We've been missed.
Thank you. So I don't know if we can, if I can ask another question, which is, where does the carbon calculator fall in? Is it 1, 2, 3, or 4?
Well, in terms of the sessions, so there's not a specific slot in terms of discussing the carbon calculator. If you're wishing to, are you wishing to make further submissions on the matter of carbon calculator?
No. It's just that there are some. I think all of the areas you have are of interest to probably nearly all the people. It's just that I know, for example, that there are people in the room today who know an awful lot more about tourism than I would ever be able to speak to. So I can't really contribute to that, but I can make contributions to some of the technical areas around the dark sky stuff in terms of some of the visual exhibits that have been prevented by Community Wind Power Limited, which I've had difficulties with. I can certainly make contribution in terms of carbon calculator assumptions and, of course, the wind stealing aspect. So I just would like to be able to, I could map myself, or you could map me to the sessions sort of immediately. I would assume that 1, 2, and 4 would be the ones that I could make a contribution to that is potentially meaningful, and the rest I would have to cede to people who have much more experience than myself.
Okay. Thank you. That'll be for you to determine which sessions you would like to be involved in, obviously in due course. But I will, I'll try and make the scope of the sessions as clear as I can in the note of the meeting. Now I did miss. I apologise. It's Merthyr Farm. I think you've got your hands up.
Yes. Myself, Eric MacDonald, and Karen Megson have made comments from our properties in our own right, but we'd like to be present, but wearing dual hats in our position as community council members for North Milk as well, our comments could be incorporated within North Milk.
Okay, no, that's helpful. Thank you. And Ms. Bruno, please.
Yes, Patrick Juck still wants to be involved with this as well, please. Thank you.
Thank you. So just reflecting upon that, I think In terms of the landscape and visual inquiry section, I would anticipate 3 days would be ample. It might be that 2 days is sufficient, but depending on the number of participants who ultimately decide to be part of that process, I think 3 days I have to be cautious and ensure I've got sufficient time to hear all the evidence and cross-examination.
So can I just raise a point? I'm obviously listening to everything that's been said. There is a concern because if, and as we'd understood, this is going to be an inquiry session.
Yes.
That it can't be I use the word free for all. There's lots of individuals. I'm not aware of expert representation. And how does that get managed, cross-examination and so on? It feels, very unwieldy. What we had envisaged was an L&V session with expert witness, and that would be with the council, and then other concerns would then be raised potentially. We were going to have a community session, then they would be raised at that level. But we can't just, it seems to me, fairly have 10 or 12 people without expert representation sort of taking pot shots at Mr. Welch, and then have no formal way of coming back. It feels to me as though that wouldn't be appropriate.
I do understand where you're coming from, Mr. Hardy. Equally, I want to ensure that those who have evidence to give have the opportunity to do so, and you would have the opportunity to test that in a proportionate way, depending on the individual's concern. So
I think what I was thinking was you do that within the those parts, what you do within the hearing was where I was getting to, I suppose.
I understand. Yeah, where I want to be kind of cautious is not having a session that's kind of deals with the meat of the technical evidence to then essentially, for want of a better expression, pay kind of lip service to it from the non-technical perspective. I think it's right to capture the views in a single session. I'm confident that could be managed. We've seen it done elsewhere, and I think what I'll do is I'll make really clear in terms of what the steps are in terms of being involved in that inquiry process, because that would apply to everybody. So it's not that those who are involved with it don't have to follow due procedure. That due procedure would still need to be followed. So hopefully that will give you some reassurance on that. And I do recognise the concern and the need to manage that process. Mr. Patterson, please, you've got your hand up.
Sorry, sir. I didn't realise my hand was raised.
Oh, no problem. And then I have the Merthyr Farmer. Is your hand up deliberately?
No.
That's fine. No problem. Thank you. So yeah, if you just pop your hands down when it's easy to forget. And Mr. Mundell, I saw your hand appear, so I'm confident that you mean it.
Yeah, I just wanted to clarify from your point of view, particularly for the many members of the community that's here, there's no requirement to have expert or professional representation in this process, and indeed I'm correct in thinking it's both the DEPA and Scottish Government policy, that it should be conducted in a way that any person, regardless of their experience or background, should be able to fully participate.
That's right. Yeah, that is correct. Yes. And in terms of kind of submissions, I mean, we'll come on to that very shortly, but I would anticipate that kind of precognitions could potentially. So a precognition is a summary of the evidence and position that an individual or witness is taking. That could potentially be, depending on the nature of representations made to date, that could be the representation could be the recognition, essentially, if that's its focus. But that would be up to the individual to decide how they would want to frame that evidence. So I think there is a need to keep it proportionate, obviously, but I think I'm not unduly concerned from what I've heard in terms of potential participation at this stage. So moving us on.
So can I just to be clear, because it's not a sort of session that I've seen before, I'll be honest. Does that mean that everybody then would be susceptible to cross-examination? I assume so.
Yes.
Because there'd obviously have to be benefit and burden. So it isn't just a case of each individual putting in a document. They would then be subject to the full rigour of cross-examination if that was appropriate.
That's right. That's correct. In terms of comparison, I mean, the most obvious one where certain individuals, including yourself, were present was the Sanka 2 inquiry, which I was the reporter for. And we had, whilst there were groups of residents in that case who were individuals and who were under the Stop Sanka 2 banner, they essentially gave individual evidence, and that was I found that worked very satisfactorily personally. So that's kind of what I've got in mind.
That's fine as long as you set it out, and there is, we are given the ability, and there's an understanding that isn't burden free, that people will be subject to questioning on that if appropriate. That's fine.
That's right. Yeah, absolutely. Okay, so Mr. Hardy, on that note, it is now 1 o'clock.
I've got 10 minutes, so I don't know whether. But again, there's a lot to get through, and what I don't want to do is rush. But if we are going to, we can certainly have another 10 minutes to get through things that,
Right, let's take that 10 minutes and we'll see where we're up to. Okay, so in terms of the hearing sessions, in terms of the community session, I don't need to know participation now. I'll ask for people to kind of confirm in due course as to who wishes to participate, and that will be part of that overall process of confirming participation in the process, which will follow and is a statutory kind of stage of this process, which I'll outline in my note. And as part of that, I'll ask for those comments as to what the scope of that might look like, and I'll then shape the agenda accordingly, so hearing statements can be prepared in advance for that. Now, for the policy and conditions hearings, now I don't anticipate that these sessions could both be held back to back, possibly in a single day, but it may be safer to allow 2 days, depending on where they may take us. So who would wish to participate in either of these sessions? Obviously, I've got the applicant. The council, I'm assuming, would be participating in both, Mr. Armstrong?
Yes, and it's the council intention to participate in both these hearing sessions.
Thank you. And Mr. Milne, I'm assuming, given what we've already discussed in terms of a PEM in January, it wouldn't be the airport's intention to participate in the condition session. I don't know about policy.
Good afternoon, sir. The MOD's position, absolutely, in terms of the seismological array, decision's been taken to have a further pre-examination meeting in January. So the MOD would not see any need to be involved in the policy session from that perspective. I think all array issues would most conveniently be wrapped up in one session next year. Insofar as the conditions session is concerned, of course, any proposition which is made regarding the suitability of a suspensive condition to deal with the MOD's objection concerning the array, again, I think most usefully could be dealt with at the array session next year. So the MOD's only interest which remains to be dealt with is insofar as aviation lighting is concerned. Now, my understanding is that the MOD's requirements have been agreed by the applicant. I think Mr. Hardy is nodding there.
Yes.
So there's just in terms of a condition to be agreed. So hopefully that can be agreed, and there would ultimately be no need for the MOD to attend the condition session.
Okay, lovely. That's helpful. Thank you. We've got Nat Safeguarding who have confirmed attendance at the conditions hearing, assuming all things being equal as they are now. Are there any other individuals who would like to participate in either or both of those sessions? Mr. Kitching.
Yeah, just with regards to conditions, just due to potentially compensatory planting. So yeah, just the condition session would like to be involved with, please.
Thank you. Mr. Lloyd, please. Dr. Lloyd.
Yeah, so as I said, I'm happy to participate in the energy and planning policy. Of course, in some senses, the scope of that may change in relation to your later determinations, but at present, that would be a sensible place for me to be. Thank you.
That's helpful. Thank you. Mr. Barker, please.
Can I just check that these are sessions that are available for all of the attendees to this particular one? to view, attend, and listen, etc., as opposed to having to make a contribution?
Yes, yeah. So I'll come on to that, but yeah, all the sessions, regardless of how they're held, will be live streamed and recorded. That's certainly the intention. So if they're held in a physical room rather than a virtual room such as this, then people can come and observe. Yeah, certainly.
Okay. Can I, as a matter of insurance, therefore, suggest that Moffat Community Council would like to be there, whilst I can't guarantee at this point what our contribution will be?
Yeah, absolutely. And what I'll do is in the note of the meeting, there'll be a request for you to confirm participation within 14 days of the note of that meeting. And it's at that point where I'd be looking for that confirmation either way. So this is purely indicative at this stage anyway. So you haven't committed yourself by saying anything at this stage.
Thank you.
Okay. So now in terms of conditions specifically, I'd like a schedule of conditions to be prepared with confirmation of whether the conditions are agreed or disputed between the applicant and council in particular, and where they're disputed, alternative suggested wording or alternative conditions should be provided. And then the hearing will largely focus on matters of dispute. Could I ask the applicant, so Mr. Hardy, to take the lead on compiling a schedule of conditions, please?
Yes, we will do that.
That's brilliant, thank you. And that's noting section 36 conditions and conditions of deemed planning permission.
Mr. Climate would like. What may I ask one question, sir?
Yes, certainly.
It's although I don't want to attend the conditions personally, may I ask that consideration will be taken into reinstatement of the landscape in the conditions.
So a kind of decommissioning phase.
If you for example, if you consent to the development, as part of the conditions, will the consideration be given by you for reinstatement of the site once the license has expired?
I understand the question. That's very likely. I suspect I can see Mr. Hardy nodding as well, and I would expect both the council and applicant to be thinking about kind of decommissioning and the conditions and requirements associated with that. So I can't give any certainty at this stage as to what those conditions will say. Clearly,
yes. But thank you for listening to me. Thank you.
You're very welcome. Okay, so in terms of leading on from kind of the need for conditions, so the focus of all inquiry and hearing sessions will be on matters where parties don't agree, essentially. So statements of agreed matters, certainly between the main parties on the topics to be addressed at those sessions, can be very helpful in focusing evidence and discussion. So for this reason, it's preferable for these to be prepared in advance of other submissions where there's the kind of possibility of doing so. So you'll see in my timeline, I've asked for these ahead of the hearing and inquiry statements so that subsequent submissions can focus on matters of dispute. There's no requirement for them, but where they are able to be provided, that can be useful. Okay, so moving on to matter 6 and dates. So in June, I indicated that I was intending to hold an inquiry in December, the first 2 weeks of December. And as far as I'm aware, all parties are available with the exception of 1 or 2 of the applicant's witnesses during the second week. So I think the first week is free for everyone as far as I'm aware. So in terms of a timescale, what I'm thinking of now, reflecting on what we've discussed, would be the landscape and visual inquiry session beginning on Tuesday, the 3rd of December. And we would allow 3 days for that. So that would be completed by Thursday, the 5th of December. On the Friday, that would be the opportunity for the community hearing session. I would be proposing that was held in the daytime rather than an evening session. Then the following week, Tuesday, the 10th, would be a policy hearing. And then we could either, I've got to be careful here, I don't want to bite off more than we can chew. So I'm going to actually say Wednesday the 11th for the conditions hearing rather than assume we can complete both in the same day. I'll take breath. Does that sound workable to everyone? And are there any concerns over the order? So if you're happy, you don't need to say anything.
No, it does factor into questions about virtual and physical, though. I just want to reserve that.
Let's come on to that now, because that's an important point. Ms. Williams, please.
Thank you, sir. I unfortunately will not be available on the Friday where you have suggested the community session. I would be available the following week, but obviously I'm conscious that there are plenty of other people who can put forward the topics that they wish to discuss.
That's helpful. Yeah, thank you. So yeah, if as the group begins to kind of evolve and form itself, I would hope that in your absence it would still be in a position to articulate your concerns on your behalf and on behalf of the wider group as part of that session. So hopefully that you won't feel that puts you at a disadvantage. Mr. Barker.
Oh, I shouldn't have my hand up. If I do, I apologise.
Even easier. There we go. Okay. So in terms of the question around, is it a virtual inquiry? Is it an in-person session? We need to give some thought to that. So some sessions could be virtual and others in person. So it's not a case of all or nothing with sessions of this nature. And there are advantages and disadvantages of both. We've got a lot of experience of them since the pandemic, where everything was virtual. You're seeing some of the drawbacks of a virtual session today, where sometimes people find it difficult to be able to stay on the call. My immediate view, but very much open for discussion, as with everything else, is that the landscape and visual inquiry session could be held virtually on the Tuesday to Thursday. But then the community hearing session, I feel, it's going to be important that we have that in person. It might then be that the policy and condition sessions could then also then revert to being virtually held. That's my initial impression of it.
That's where I'd got to as well. Listening to the issues, I think the community hearing has to be in person. So we would agree with that. So virtual for LMV, in person for the community session on Friday, and then reverting to virtual for the following week.
Are there any contrary views to that? I can see a few hands up and I will come to you, but are there any contrary views?
Mr. McClimate has a view.
Mr. McClimate.
Yeah, I think this is a really significant impact on the area, and I think the landscape and visual is showing.
Oh, I've lost you, Mr. McClimate. I don't know if you can hear me.
Hello, can you still hear me?
Yeah, I can now. It broke up.
Sorry, my phone data was getting low. So I think the land it's massive, the landscape and visual session, and to have a hearing where the public may attend, I think is to be considered. But obviously you are the man in charge, and I respect that. But I think the landscape and visual is so important overall that it may be beneficial for everyone to have it held within within a room setting. Thank you.
Thank you. Mr. Armstrong, please.
So it's the council's position that they would, for an in-person session, particularly for the landscape and visual effects session, there's clearly, as we've heard today, a number of people potentially going to be involved in that. And certainly in my experience, if there's more than perhaps 2 or 3 parties involved in a session, there can be difficulties in relation to people losing connections, which would result in the session having to stop until they were back in position. Again, there's a considerable amount of public interest in relation to these matters, and so it's the council's strong position that it should be an in-person session in relation to landscape and visual effects. That also goes for the energy and planning policy session, although there's potentially going to be less people involved in that. And I can see an argument for that potentially being a hearing session. For the conditions session, I can see an argument for that being online. So the preference is for all three sessions to be in person, but the council accepts that there are arguments when there's only one or two parties involved that the sessions could be online.
Thank you, Mr. Armstrong. Mr. Barker, please.
Can I please echo the sentiments from the council? Not only is it important that the community session takes place in Moffat, I think it's of great public value that the discussions around visual impact are held in the location where the wind farm is being proposed. And I think the community should have the opportunity at the broadest possible level to understand other people's perspectives on the landscape we have in Moffat. So I would urge you for those areas to consider what the council has just said and hold what you can in person here in Moffat, please.
Thank you, Mr. Barker. Dr. Lloyd, please.
I would echo that. I think that's really important. I do wonder whether there is any possibility of a weekend session at all for that. Is that possible at all, just to make sure that people who are juggling quite a few commitments can at least be fairly confident they're able to make a weekend meeting at this stage, whilst they may not be able to be certain about their work timetable that far in advance at this stage?
It would be exceptional to have a weekend session. In terms of the sessions that I've outlined, I'm assuming, are you referring to the community session in terms of when that's held?
So yes, I was referring specifically to the community session, not the rest of the process. So I understand the need for lots of people to be in the same place for all of the sessions. I'd echo all the points that have been made earlier about that. I just thought that in terms of the community, and following on from what Mr. Barker had been saying about the importance of getting people in to listen to all the views about how the landscape is to be used and affected, it would be great if it was possible to hold that perhaps on a Saturday to allow the widest possible representation of people who would like to contribute.
I suspect that would cause, it's likely to cause some difficulties to accommodate over a weekend. I'm happy to hear alternative views to that, but before I do, Ms. Wingfield, you have your hand raised.
Thank you. I would fall in behind both Dumgall Council and Moffat Community Council in requesting that the L&V session is held within the community. There are an awful lot of people who are very, very interested in the locale, within the locale in seeing the proceedings, and I think it's crucial that in order to encourage people to view proceedings, that it is held ideally in Moffat or Lockerbie.
Thank you.
Thanks.
Mr. Hardy, any brief reflections on that?
There's competing views. Our view is that your initial suggestion was appropriate and right. That's the one we would ask you to stick with, but your form of view. In relation to weekend, I mean, that just isn't acceptable. I'm not sure, whether you were going to take that very seriously, but there are, there's work-life balance, there are families, there are travel, all the rest of it. A weekend is simply not fair. And if members of the community want to take part, then there is going to be ample opportunity in that first week to do so. We're actually being given a full day, for hearing sessions. So stick with what you had, absolutely not to a weekend.
Thank you, Mr. Hardy. I don't intend to make a final decision on the precise kind of combination of virtual and or in-person sessions now. I'll reflect on what's been said and give that some more thought. Mr. Barker, is your hand up deliberately? You're on mute. You're on mute, Mr. Barker.
We're going through a process that is going to have an impact, whatever the decision, for decades. I think it's very valuable for those people making that decision, see the community they're in, and start to understand the potential implications. And that's a further argument holding as much as possible in Moffat. So we're dealing with the reality of the situation on the ground and not hypothetical situation online. Thank you.
Thank you. Okay, so for any in-person sessions that are held, well, in terms of venues, I need to give some thought to that. We need there are some basic requirements that would need to be met. So we'll need excellent Wi-Fi, obviously, for webcasting purposes. We'd need a room of adequate size, which is accessible to all as well, and ideally with good heating and ventilation. And we've got the challenge around Christmas in terms of finding a room of that size that's available on the run up to Christmas, which might prove challenging. But if there are any obvious venues which you think we should be exploring, either tell me straight away now, or you can contact the office. That would be really helpful. Mr. Mundell.
Yeah, I was going to say I don't actually think that'll be an issue in the case of Moffat, because there are multiple suitable venues. There's the town hall, which may have things on it, but I suspect they will be willing to look at accommodating this. There's the Old Well Theatre. There is the newly renovated St Andrew's Church, which is available as a community space. There are a number of hotels. There is the Proudfoot Social Club and Institute. So I mean, there's a kind of number of venues, and they're all in close proximity. So I suspect, with a wee bit of creativity, it would be possible to work even across a couple of those venues. They're all in walking an immediate distance. I mean, I don't think it should be a challenge.
Thanks. That sounds promising.
So can I just interrupt? I've
Certainly.
put off the other engagement that I've got, and actually we've been going for a long time. So I wonder whether or not I could just ask for 20 minutes or half an hour to make that to do that other engagement. I'm sorry to break into proceedings. It feels like we've probably got another 10 or 15 minutes. I'd have thought.
Yeah, certainly not. Yeah, I would say certainly not more than that. But I would be able to just wrap it up immediately. So I think if I mean, I take the point. Certainly, we have been going for quite some time. It's quite unusual for a pre-examination meeting to go on this long. So I appreciate you got other appointments as well. Would 20 minutes be sufficient?
25 minutes. Can we say 1:45? Would that be compromise?
Mr. Mundell.
I was going to say, if we were going to stop, I've also got something else on myself, and I think having a sort of, as in it's either one or the other. I think having a shorter break makes that more tricky for me. But I'm equally happy to be finished if and not come back if that's.
It's a bit of an unorthodox suggestion, and Mr. Hardy, I'm in your hands. I think we've covered essentially the elements that will be of interest to yourself and the applicant. So what I would like to touch upon in terms of what's left is kind of some of the practicalities around dates for submission, which are hopefully as read in my annex. So if you don't have any points on those particular points, I don't know if you've got somebody with you who could deputise. Would that be a possibility?
I was just wondering that whether or not. Just take a.
I think the heavy lifting's done, essentially.
Yeah, I wonder whether we might be able to do that. So there's Thursday. I don't know whether or not. What have we got to do? We've got to do site inspections, dates.
Yeah. So really, the only meets left is a kind of around dates for submission. But I was going to say a little bit for the benefit of those who are less familiar than yourself with the process about what we follow.
I think Kirsty Kelshaw from CWB can deal with those. So she's obviously apprised of all of this. She's legal counsel with CWP and she's on the call. So if that's all right, so without any disrespect, if I can leave those to Kelshaw, that would be great.
It was my suggestion, so certainly no disrespect taken.
Thank you very
That's absolutely fine.
much.
Thank you.
Been very constructive. Thank you very much indeed.
Thanks for your time.
Bye
Much
bye. Bye bye.
appreciated. Hopefully see Ms. Kelshaw's screen appear any moment.
I am here. Hopefully you can see me.
Something's happening. Yes, I can. Thank you. Hi there. Okay, so right, so I'm reassured about venues. That's good. We will get to work. And yeah, any suggestions that you have beyond what Mr. Mundell's outlined there would be helpful if you think that's the ideal place, especially if you know if they've got availability. That will save the office a little bit of work.
So I've got my hand up.
Oh, apologies, Mr. Armstrong.
So the council checked this morning, and Moffat Town Hall is available. Our understanding is it is a suitable facility, and it can hold up to 100 people in one of the rooms. And the only question mark over the 2 weeks is on the 11th of December, where there may be an issue, but otherwise it is available and it can be booked. It is, as far as the council is concerned, an appropriate venue for holding either hearings or inquiry sessions.
That's really helpful. Thank you. That sounds encouraging. And given the 11th of December is the date, I'm thinking purely for the conditions hearing, where that seemed to be there was more appetite for that to be virtual rather than in person. That might not cause us a difficulty anyway. So okay, I'll follow that up. Thank you. Great. So let me just take stock. Okay, so just to say a little bit about what you can expect in terms of next steps, I think that would be worth just covering before we finish. So in terms of the process leading into the inquiry, essentially the intention is that all participants in a session give prior notice of their arguments and of any documents to which they intend to make reference to. So we're not looking for surprises or to catch out the opposition. That's not in the spirit of an inquiry session, and it's not something which I'd be allowing. So there has to be prior disclosure. You have to set out what your case is. So that ensures fairness for all parties, and that enables counter arguments to be prepared, and that enables me to then form a view properly on the case. Now, all parties taking part in the landscape and visual inquiry session must submit an inquiry statement by the relevant deadline, which is in the annex to my agenda. Likewise, for the hearing sessions, a hearing statement will be submitted, and there's no word limit for either of these documents. Now, these statements should outline your case. They should list any documents to be relied on and identify the names of those who will be speaking at the relevant session and the topics each will cover broadly. A single core documents list is preferred, and which is managed by one party, and this would normally be the applicant. Now, this helps to minimise any duplication of documents on the website, which can cause confusion, especially in instances where the same document is sometimes lodged more than once, but with a different name or reference number. There can be issues of version control, etc. So a core documents library is really helpful. Could I just check, Ms. Kelshaw, would the applicant be happy to take a lead on this, please?
Yeah, I think we've done it previously, so I don't think it'll be an issue this time round.
That's great, thank you. So I'd like to ask for parties to cooperate in the preparation of this list and to ensure the relevant documents are made available in accordance with the agreed timescale. So in addition to the documents already submitted with this application, the DPA holds a library of published documents to guidance on how parties can prepare the list, particularly the applicant. Making use of that library is included in Annex C to the agenda. So all core and other documents should be lodged electronically, either in Word or PDF format, except illustrative material for which paper copies should also be submitted. Now, Mr. Reclimont, you made reference to a video submission. We can deal with that separately between the office and yourself, should you wish to make that submission.
Thank you. Yes, I'll discuss that with the office. Thank you.
That's great, thank you. So each witness giving evidence to the inquiry session, so I'll stress that's the landscape and visual inquiry, not any of the hearing sessions, must submit a precognition. So the deadline for this will be no later than 14 days before the start of the inquiry. So I think that's the 18th of November. That's a key date. Now, each precognition must be no more than 2,000 words, and I'll not accept appendices or links which extend the length beyond the word limit or introduce documents which other parties have not previously seen, because these should be submitted by the earlier document deadline. As I mentioned before, for individuals who are representing themselves in particular, I'd be happy for your earlier representation to be used as your precognition, as long as it doesn't exceed that word limit of 2,000 words. Now, regarding further written submissions, I'll confirm details of the information I'm seeking and from whom in my meeting note, together with the deadlines for this, although I've outlined my intended deadlines in the annex. So I'll stop and draw breath again. Is there anything else under item 6 or any comments or concerns about the timeline in Annex B? Dr. Lloyd.
Just a query, you asked for further written submissions from me and I believe from Mr. Hardy. Is that correct, or does one have the right of response to the other, or is there a precedence here? Does one submit before the other? Do we joint submit and then see each other's submissions? How does that work?
Very good question. Yeah, I shall say a little bit about that. So essentially, the process will be that you do technically have the right to respond at the same time, and then you would be given a further opportunity to comment on each other's responses. However, sometimes, depending on the question I would be asking, I would frame it so I was looking for a particular individual or party to respond first and take the lead to essentially provide something for the other party or parties to respond to. So it can be tailored essentially to the specific question that I'm asking as to what's going to get the best information out of that question being answered. So I will give careful thought to the wording of the question around wind steering, which we've discussed. And I'll think about the kind of choreography of who's asked what and when. But you will have a statutory opportunity to be able to comment on the applicant's response to that. Mr. Armstrong.
Yes, sir. Just in relation to one point on Annex B, and it's the deadline of the 21st of October, where you've got statements of agreement, conditions, and core documents list, and you've got due by 25th October. So it's week commencing 21st October. And certainly in my experience, it would be of assistance if there was a sort of structured approach to drafting statements of agreements, draft conditions, and draft core documents. And that because there's going to be a number of parties involved in this, I think it would be helpful, sir, if you could perhaps set that structure out in your note of this meeting, because obviously the council will be, the applicant is preparing a draft list of conditions, I assume a draft statement of agreement, and the draft core documents. The council will then be responding to that and will obviously require some time to respond to that. So if perhaps the drafts could be prepared at the beginning of October for the council and all the other parties then to respond. I think, as I say, because there's a number of parties involved in this, it would be more helpful if you could set out that structure rather than having an attempt by all the parties to try and agree dates for draft core documents, draft conditions, and draft statements of agreement. So if we could have a structured approach with the drafts perhaps produced by the applicant early October, there's perhaps 2 weeks to respond to that, and then the final drafts are then produced for the 25th of October, and where there's disagreement, say for example in relation to conditions, that would be set out in the final drafts.
Thank you, Mr. Armstrong. I was smiling slightly as he started because my original version of Annex B did have those draft dates, and I thought I didn't want to bombard people with too many dates. So, lesson learned, I shall revert. And I think, yeah, I'm quite content to put dates in. I suppose they would be, from my perspective, those dates are for parties to work together too. And if they slip, I'm less concerned about that from my selfish perspective, as long as those final deadlines are met. So there's that ability for you to work with others, and if more time is needed on certain points in terms of drafts, that doesn't really cause me an issue. But in terms of the timescales for final submissions, that's what I'm really focused on myself. Hence why I took them out of this timescale. But point noted. Thank you. Okay, so I shall move on then to item 7, and this is kind of covering various matters which we can probably move through very swiftly. So just a note on site inspections. I've already made some site inspections, including within the site and some of the representative viewpoints and surrounding area, and also in the vicinity of most of the nearest residential properties. I intend to make some more visits between now and December. If necessary, I may also make some follow-up visits once I've heard the inquiry evidence. So if there are any particular locations which parties consider it essential now that I visit before the inquiry, I'd invite you to let the office know, and I'll try to accommodate this where it's practical to do so. I'm intending to make, as I said, pretty extensive site inspections before the inquiry. So there shouldn't be too many gaps in my kind of knowledge in terms of viewpoints and areas before the inquiry or by the time of the inquiry. So is there anything anyone would like to raise now in terms of site inspections? Mr. Mundell.
It was just on that point, will you share the kind of locations and sort of places where you're thinking of as well with all parties? Not just to give you, I guess I think there are a number of significant kind of walks and trails kind of around Moffat. I think would give you different vantage points, and it's just whether you kind of want to be kind of bombarded with those, or whether you're going to look kind of in the site, around the site itself.
Yeah, well, I'm going to do both. So, but if there are particular, I don't mind being bombarded. It's the nature of an inquiry. I'd rather be told you need to go here rather than not be told and I haven't done it. So feel free to contact. But I would reassure you all that I will be making extensive site inspections, so I have a very good sense of the sort of locality and the wider area. Ms. Wingfield.
Can Mr. McClimate speak?
Just a moment, Mr. McClimate. I'll come back to you in just a moment, please.
Thank you.
Thank you, Ms. Wingfield.
Thank you. It's slightly allied to what Mr. Mundell has just asked you in terms of providing a list of the areas that you may be going to for site visits. If it's not on your list, I would strongly urge you to consider popping on a pair of very stout boots and climbing to the top of Range Castle Hill, which is actually behind, it's on the property of Karen Megson and Eric MacDonald that are participating in this call.
Yes, yeah, I've been very close to it and I haven't been to the summit yet, but I will add that to my list.
Thank you.
Thank you. And Mr. McClimate, please.
Yes, Mr. Warren. May I suggest, and it's only a suggestion, that the opportunity on a very good day allows you to view the site from an aerial perspective, or if you're bird's eye view, if you like, could you accommodate that? Thank you.
Thank you. Yeah, unfortunately, I suspect our DPA budgets don't stretch to aircraft, as lovely as that would be. I mean, I think in terms of the opportunity to see it from an aerial perspective, that is really going to be either from summits or from the likes of Google Street View, which might not sound particularly satisfactory from your perspective, but realistically, that would be the means by which I would be able to do that.
Well, God works in mysterious ways. Let's hope. Thank you very much.
Thank you. Yeah, so in terms of the DPA website, That's going to be the most effective way for keeping abreast of the case and proceedings. All the documents submitted there are uploaded for you to be able to view, and I'll include a link to that in the meeting notes, so you have a direct link to the case. In terms of making contact with myself and the office, if you wish to contact the DPA about the case officer's name is Audrey Devoy, and I'll put Audrey's contact details in the notes of the meeting too. You won't be able to have direct contact with myself for obvious reasons. Now, in terms of the daily programme for the inquiry and hearing sessions, so on the first day, so on the Tuesday, the session will start at 10 a.m. and on subsequent, and this is regardless of whether it's virtual or in person. On subsequent days, this would start at 9:30 a.m. and we'd look to conclude around 4:30 or 5 or thereabouts. We'd take short breaks in the morning, and I can guarantee you would get a lunch break as well, unlike today where we're pushing through. So it'll be important that we're not too ambitious with how much progress we can make in a day, and I'll make sure that there's time built into the programme for some overrun. In terms of webcasting, whether or not we have an in-person or virtual inquiry or a combination of the two, it's intended that all sessions will be live streamed and recorded so they can be viewed on the DPA webcast site. And then finally, the note of the meeting is a critical part of following on from today. So I'll aim to issue my note of the meeting within the next 7 days, where I'll confirm dates and all the matters which we've discussed this morning, including the sessions that will be held and the further written submissions requested and the deadlines associated with all of those. There's a critical point which I'll flag up that I don't want to be buried in the meeting note. Parties must notify the DPA within 14 days of receiving the note of the meeting whether or not they intend to participate in any hearing or inquiry sessions, and if so, in which they intend to participate. That's a formal stage which must be adhered to. So I'm just flagging that up for your awareness now. Are there any questions or matters which anybody would like to raise before I draw this meeting to a close? If not, it just leaves me to thank you for your patience this morning and into this afternoon. It has been a long meeting. We've covered a lot of ground. Greatly appreciated. It's been very helpful. And I'll look forward to seeing you again in December. So thank you very much.
Thank you, Mr. Warren.
Thank you.
Bye-bye.